This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi everyone, welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed. We are reading through the entire transcript of the 1996 Menendez brothers trial because we don't have video of it. We have video of their first trial, which was in 93, 94. This is now their first trial ended in a mistrial. So now they are back on trial in 1996. And we're going to continue on with Diane Vandermolen's testimony. She is an older cousin to the brothers, and she spent multiple summers there in that house. I think in the Pennington house. I can't remember. There were multiple houses, many moves. So they lived in New York, they lived in Jersey, I think, they lived in Illinois, they lived in California. There were many different homes, but I think this was all on like the East Coast part. Maybe even Pennsylvania, I want to say. Something along those lines. So there were all these different homes but mostly, the two homes that she talked about on the stand in part 73. So we are, by the way, we're on part 74 of the defense's case out of 92, which means we're getting close to the end of the defense's case. We have experts and things to get through and lots more arguments between the state and the defense because that's just how the whole trial has been going. Lots and lots of arguments. So, in this episode, we're going to continue on with Diane Vandermolen's testimony. They took a break and kind of argued some things. And if you recall, this is a totally different trial because the state is fighting so hard to keep anything about the abuse out. The judge pretty much sides with the state like 95% of the time. And so it's quite difficult for the defense to get in all of their different all of the different strategies that they're trying to use to get in the abuse and things like that. And it's not working because Diane Vandermolen was not allowed, or in this particular trial, she's not allowed to testify to the abuse that Lyle told her was going on. He came to her when he was young and said, I think about 9 or maybe even younger than that. He came to her and said, Jose was touching him inappropriately. She tells Kitty. Kitty just ignores it and says, I don't know what you're talking about. That's not happening. Shh, go away. Pretty much ignores it. So that was not allowed to come into this trial. So the only thing the only thing stating in this trial that Lyle was abused was Erik's words in the testimony, and they're not allowing anything to come in to corroborate that because they're twisting all the different ways to work the law and say, no, you don't need that. So whatever. The court and the prosecution, I think, are in cahoots. But anyways, let's thank our founding justice insiders. We have Toyota Girl 67, SLB 29488. May the force be with you 4313. Jessica Weenan 6079. Mrs. Apples 2007. Butler 89833. Brooke JF. Jen P 773. And Boom Chickawawa 1, and finally Kendall B 5757. Thank you all for being founding Justice Insiders. I know there are more Justice Insiders I have to update, so they're coming. I just haven't had a chance to update my intro yet. So there are other Justice Insider or founding Justice Insiders, I should say. So those that I have not mentioned, thank you also for your founding Justice Insider memberships. Unfortunately, the opportunity to become a founding Justice Insider is no longer available, but you can still become a Justice Insider and your name will be read on screen as well as a Justice Insider. So, with that being said, let us get back to our testimony. So we are on Wednesday. This is Wednesday, January 17th, 1996, and we are coming back from lunch. So Diane Vandermolen was on the stand. So the court says, okay, everyone is present. We'll have the jury out, please. The jury enters the courtroom, and the court says, all right, everyone is present. You may continue your direct examination. Ms. Abramson says, thank you, Your Honor. Ms. Vandermolen, we were talking about how Erik and Lyle Menendez behaved differently towards each other when their parents weren't around. I think you described it as they acted more like buddies. Yes. Than competitors. Yes. Now, with respect to other behaviors that you noticed by Erik and Lyle Menendez when their parents were not around, did they talk differently? Yes. They talked about how they felt about things, about what their hopes and their own aspirations were, and what they liked and disliked about whatever. Did they talk that way when their parents were around? No. Conversation was given to them. What do you mean given to them? It was directed. Objection, irrelevant. Evidence Code Section 352, says Mr. Conn. I think this 352 must have something to do with, like, don't disparage the victim or something. That's what I think, because every time they kind of say something that might have anything to do with abuse, it's like, oh, objection, irrelevant, and this Evidence Code 352. So that's what I'm assuming. I could be totally wrong. I should look it up, but I'm not going to because we got a lot to get through. So the court says the answer will stand. Let's move on to something else. Ms. Abramson says, thank you. During the course of a typical day in 82-83 period when Mr. Menendez would be, say, at work and Mrs. Menendez was home with Erik and Lyle Menendez, was there a regimen of things that they had to do? Yes. Objection irrelevant. Evidence Code Section 352. Ms. Abramson's like, that's just foundational, Your Honor. Okay, well, then objection sustained. The answer is stricken. Let's get to the issue. Ms. Abramson says, would there be a list of things? Objection irrelevant. Ms. Abramson says, I haven't finished the question yet. Court says, all right, please do so. Thank you, Your Honor. Was there a list of things originating from Jose Menendez that Kitty Menendez would require Erik and Lyle Menendez to do each day? Objection irrelevant. Evidence Code 352. The court says, is this the foundational question or something? That's the question, says Ms. Abramson. Okay, overruled. You may answer the question, says the court. The witness says, yes, Kitty would. The court says, you answer the question. Okay, says the witness. He just doesn't want, like, more detail added about these parents. They're trying really hard to keep out character evidence, like this person treats this person poorly. This person abused this person. They're trying to keep all of that out. So you can tell by the objections and things. Ms. Amerson says, were there some of the rages that you described that you saw Mrs. Menendez go into? Did failure of one or the other of the brothers to fulfill an item on the list sometimes cause those rages? Yes. Would you see Erik and Lyle over the course of the day reporting into their mother concerning their progress on the list of items? Yes. Why would a parent even want to, like, do that, let alone, be so controlling over the kids? But, like, why would you even want to know everything that they're doing? That's so sick and psycho. I don't know. I grew up with a mother who she said her mother spied on her and, like, read her diary and stuff. So she said she was never going to do that with her daughters. So she gave us our privacy, which I appreciated immensely more than, I'm sure I even know, because most kids probably do have their parents, like, spying on them and stuff, especially like younger ages. But my mom was very, she was adamant that she didn't like it, so she wasn't going to do it to her kids. So I don't know. I think it's kind of strange to want to, know every second of every day what your kid's doing. That's weird. And that's pretty much what every second of their day was planned with, like, progress reports to go do things that Jose wanted them to do, like work on your backhand or whatever. I have no idea. Any of the terms of tennis, but you know what I mean? So he would make them do certain things during the day and they had to check off the list. And that's what she's talking about. That's psycho to me. But they don't want it to sound psycho, so they're trying to like not let all of the details come in, obviously, with these objections. Next question. Would you see Erik and Lyle over the course reporting to their mom? Yes. Now, you corrected me at lunch that I led you astray in one of my questions about the sliding door? Yes. Were there more than one set of sliding doors in the house? Correct. There was a pair of sliding doors in a basement, and, says the witness, there was also a pair of sliding doors that went out to the back on the main level of the house, of the family room. Were there stairs down from that deck to the tennis court? Yes. And on which set of sliding doors was the defective door that you noted? It was on the sliding glass door that was on the main level of the house that separated the family room from the deck. So not the basement set? Correct. So I was wrong. Okay, can you remember, apart from failing to fulfill the objectives of the daily list, can you remember any specific things that Erik Menendez did wrong that brought down one of these rages on him in the 82-83 period? I recall once he broke a glass in the kitchen. On purpose or by accident? No, it was an accident. What was Mrs. Menendez's reaction? She flew into a rage immediately. What was another example of something that she did which she responded to with a rage? He was at the table and was eating and accidentally spilled a glass of milk across the table. This is when he was 12? 12 or 11. Was this a formal dinner, the table set with the finest linen, or just an ordinary meal? No, it was the table and whatever plate he had. Was Mrs. Menendez at the home when this happened? Mr. Menendez. Was Mr. Menendez at home when this happened? No. Was Mrs. Menendez more likely to fly into the rages when her husband was not home or when he was home? When he was not home. Interesting. So she was more likely to go into these like fuming rages where she would clench her teeth and do this with her arms and fists. So she was more likely to do it when Jose was not there and it was just her with the kids, which makes it even scarier because there's no like protection from that, or buffer, if he could stop her from going into the rages perhaps. Anyway, so when he was home and either of the Menendez children did something wrong, would she be the one to react or would Mr. Menendez be the one to react? No, Jose always did. Did you notice a mode of speaking that Erik Menendez engaged in concerning how he'd select words or the manner in which he'd talk when his father was there versus when you were alone with him or alone with him and his brother? He was very carefully selecting words with a marked difference between carefully placing his words, making sure he was careful about what he said. Under which circumstance? When he was in his father's presence. Did you observe Mr. Menendez? Well, first of all, let me go back to something. You talked about these quiz sessions when Erik Menendez was being given mock tests of some kind. Oh, yes. Did Mr. Menendez ever participate in talking to Erik Menendez when these things were happening? Objection irrelevant. Sustained. Did Mr. Menendez, in your presence, get angry and berate Erik Menendez during the course of these timed quizzes? Yes. Objection irrelevant. You guys don't want to see his butt. He likes to play outside and then run in and check in for a little bit, and then he'll run back outside. I don't know. He's a goofball. Sorry, he's cozy now. So objection irrelevant, of course. Evidence code 352. The court says overruled. The answer will stand. So she did see Mr. Menendez get angry and berate Erik during those timed quizzes at dinner time. Was it dinner time? Did she say dinner time? I don't know if she prefaced it by dinner time, but anyways, the court says move on to the next question. And Ms. Abramson says, thank you, Your Honor. Were there times when you overheard or viewed conversations between Mr. and Mrs. Menendez and Erik Menendez on the topic of his having received bad grades? Yes. Could you describe the tone in which his parents would talk to him concerning bad grades? Objection irrelevant, code 352. Sustained. Did Erik appear fearful when his parents were talking to him about grades and the need to get good grades? Very. Did you observe following sports practices in which Mr. Menendez participated in training or drilling of Erik Menendez and Lyle Menendez? Did the three, or Mr. Menendez, Erik Menendez, and Lyle Menendez, do something together routinely? Yes. What was it the three of them did together? The routine was, after they came off the court, to go upstairs and go into the bathroom, shower together, and then follow through that by going into the den and having lessons which were given by Jose in the den. Objection irrelevant. Evidence code 352. Overruled. The answer will stand. Ms. Abramson says, and this showering together was going on in 82 and 83? Yes, very regularly. Did you see a characteristic pose that Erik Menendez and Lyle Menendez would take when their father was talking to them on the tennis courts? Yes. Would you describe it? They would look down, their shoulders they were just down to the ground. Did you ever overhear Mr. Menendez berating them on the tennis court when they were in that position? Yes. Did you ever hear either one of them answer back? No. Did you ever hear either one of them ever answering back at all? Ever? No. I have nothing further, Your Honor. The court says any examination on behalf of Lyle Menendez. Ms. Towery says, no, Your Honor. Okay, cross-examination. Mr. Conn says thank you. So Mr. Conn will be doing the questioning for the state. Ms. Vandermolen, you refused to talk to the prosecution. Is that correct? I was approached yesterday morning as I was preparing to take the stand and told Detective Zoller that I'd rather not at that time. Yes, that was the first time I'd ever been approached. Really? That's interesting. But yet you're going to try to sit here and blame her like you never talked to us. You guys never asked. Yes, so you were asked yesterday morning if you would be willing to talk to the prosecution. Is that correct? I was standing outside the courtroom door and anticipating taking the stand. Did you take the stand yesterday morning? No, as it turns out, I'm here today. Yes. When was the first time you took the stand in this case? Today. Ms. Abramson says, object to that. It's irrelevant. I would object to this whole line of questioning. It's irrelevant under 350 and 352. Overruled. Mr. Conn says, you didn't take the stand until, is that correct? Until today? Yes. Okay, and you were asked about 9 yesterday morning if you'd be willing to talk to the prosecution. I don't know what time it is. Well, it was early in the morning. Is that correct? Mid-morning. And you told Detective Zoller, Ms. Abramson says, objection, calls for hearsay. The court says overruled. Mr. Conn says, you told Detective Zoller that you were not willing to talk to the prosecution. Is that correct? I told him that I was nervous about taking the stand and would rather not do so at that time. This is not making the prosecution look good. but yet he's really going in on this line of questioning for some reason. Okay, so later in the day, when it turned out that you didn't take the stand, did you ever tell Detective Zoller or tell the prosecution that you'd be willing to talk to us for a few minutes? I've never been reached by the prosecution either before or since. I've been here. You guys could have found me. I was right here. Okay, the question is, as it turned out, when you didn't testify yesterday, did you approach the prosecution at any time or approach Detective Zoller and say to him that in light of the fact that I wasn't called as a witness, I now have a few minutes to talk to you? Objection, asked and answered, calls for hearsay and argumentative. Overruled. The witness says no. Mr. Conn says, okay, and is that because you have no interest in providing the prosecution with any information that could possibly be used against your cousins over here? Can you repeat the question? Ms. Abramson says, objection, argumentative. Rephrase the question, says the court. Mr. Conn says, is that because you have no interest in providing the prosecution with any information that could be used against your cousins? Objection, assumes facts, not in evidence. Overruled. I don't have any information, says the witness. I don't have any information that could be used against them. Mr. Conn says, I don't know what you're referring to, she says. Yes, the question is why you refuse to talk to the prosecution in this case. Objection, asked and answered. The court says, all right, that's not a question, so why don't you ask a question? Mr. Conn says, yes. Can you tell us why you refuse to talk to the prosecution? I told Detective Zoller, Ms. Abramson says, objection, asked and answered. Overruled. The witness says, I told Detective Zoller yesterday exactly why I did not want to talk to him. Mr. Conn says, were you aware that your mother and sister have refused to objection? Excuse me, Mr. Conn. Court says, wait, one question at a time. Ms. Abramson says, I'd ask to approach on this whole attack mode. The court says, okay. Incorporating hearsay, which is objectionable, says Ms. Abramson. The court says, well, the request to approach on any mode is denied. The question does call for hearsay and the objection sustained to the question. Mr. Conn says, okay. Are you willing to talk to the prosecution outside the witness stand today, Mr. Vandermolen? Yes, I am. Okay, now you said that you began going to the Menendez home in 1976. Is that correct? Correct. How much time did you spend with the Menendez family in 76? 3 months. And then you went there again in 78? Correct. And you spent 4 months there. Is that correct? Yes. And then you went again in 79, is that correct? Yes. How much time did you spend with the Menendez family in 79? Approximately 2 weeks. Okay, and then you went back in 83, is that correct? Yes. How much time did you spend in 82? 1 year and 1 month. You said that you adored Kitty Menendez? Yes. In reference to the 1976 visit, why did you adore her? She was my mentor. What do you mean by that? I mean a definition of the word. Well, perhaps you can explain what it was that about her that caused you to adore her. She took a objection 350-352. Court says, I'm sorry. We would object under 350 and 352. Sustained, the answer stricken. So if I can't talk about, the bad stuff, we can't talk about the good stuff about the character either. If I can't bring up the bad stuff that Kitty did to my clients, you can't bring up the good things that people liked about Kitty. Because it's all character evidence. And why should you get to bring in good character evidence and I can't bring in bad character evidence? Anyways, Mr. Conn says, you liked her? Yes. Object, same basis, overruled. Why did you like her? Same basis, same objection, sustained. Did you continue to adore her in 78? Yes. Did you continue to adore her in 79? Yes. Did you continue to adore her in 82 and 83? All I can answer to that is that I found it impossible to please her. Well, I'm asking you if you continue to adore her. I continued to try in every way that I could to please her and could not do so. I don't think the prosecution was ready for these answers. So you no longer adored her by that time? I loved her. Did you continue to love her in 82 and 83? I sought her approval. Well, the question is, did you continue to love her in 82 and 83? That's my response. You sought her approval? I loved her deeply, and I was continually trying to please her. Are you afraid of saying something wrong here? I am nervous about being on the stand, just like I told Detective Zoller yesterday, yes. The question is, did you love her in 82 and 83? Objection asked and answered. The witness says, yes, I told you that. Overruled. Mr. Conn says, and did you return to visit the family after 82 and 83? I returned to the home while still living in Raritan, outside the presence of the boys. Well, how often did you return to visit the family? Excuse me? After 83, how often did you return to the Menendez home? If there's a difference as far as you're referring to the house or if you're referring to the family. Well, how often did you return to the house? My grandmother was staying there and I was allowed to visit if no one else was home. That's a weird arrangement. So either Jose or Kitty's mom's, one or the other, is staying at the home, and for whatever reason, Diane Vandermolen isn't allowed with Kitty when Kitty and Jose and the boys are home. It's odd. I don't know what that's about. So they must have had a falling out or something. Your grandmother stayed there during what period of time? The rest of 83 and into 84. Did you visit the Menendez family at that time in 83? No. I was at the house, but I did not visit the family. Now, why did you go to the Menendez house in 76? Object to form or object on relevance grounds, Your Honor. I can talk. Sustained, says the court. Mr. Conn says, well, was it just a friendly visit? Objection. Same objection. Court says, what was her purpose in being there? Yes, says Mr. Conn. All right. Well, why don't you rephrase the question then? Yes. What was your purpose in being there in 76? May I answer fully? Ms. Abramson says, well, the court says, the witness says, I had looked forward for quite some time because they were supposed to be a very special family to our entire extended family to going to there. So it's like it was viewed as a very special prize to go stay with them, I guess. Mr. Conn says, a very special in what way? They were like the royalty of our family. That's all I can tell you. So everybody just loved and adored Kitty and Jose and the boys because they put out the image that they were perfect and there were no flaws in the family. Remember? Kitty didn't when Diane or family came to stay, they were all given rules about things not to talk about, what they could and couldn't bring up. Like Eric's failing grades or doing poorly in tennis or whatever it might be, it was always everything's fine, we're doing great, and we're successful at everything in life. It was the Facebook version of the family that the rest of the family was getting. Royalty, because they were rich and successful, it wasn't about the money. It was because my impression was something that was given to me by my grandmother of them. Did your mother encourage you to visit the family? Yes. And you were 17 years old at the time. I was 16 and turned 17. Your sister also went along with you, is that correct? Yes. And you were living at that time in Arizona? Yes. And you and your sister flew from Arizona back to the East to spend the entire summer with the Menendez family. Is that correct? Can you repeat it, please? Yes, you and your sister flew from Arizona in 1976 to spend the summer with the Menendez family. Is that correct? Yes. And your sister left before you did. Is that correct? Yes, she was very unhappy. Uh-huh. And you stayed because you were enjoying yourself. Is that correct? Yes. Now, can you tell us what was the purpose for going back in 78? For similar reasons. You still regarded them as royalty? No. The royalty part of it came from my grandmother. I regarded them as being part of the family. So you saw yourself as a part of that family? The whole, yes. You felt very welcome by Jose and Kitty Menendez. I didn't quite have a relationship with my uncle at all, the way I did with my aunt at the time. So I can't. But you still felt a part of the family, is that correct? Yes. Did you go places with the family? Yes. Did you go on trips with the family? Yes. Did Kitty Menendez take you on trips? Yes. Sightseeing trips? Yes. Ms. Amerson says, I'm going to object to this and beyond the scope and under 35352. Court says, I'll permit this question, but go on to some other subject. Mr. Conn says, was there an answer? Oh, yes. Sorry, we did. Yes. What was your purpose in going back in 79? I took a friend with me who had wanted to see the East Coast. Who was that friend? Your Honor, I can't hear the witness. The witness says, Karen. Mr. Conn says, what was her last name? Eanes. How do you spell that? She spells it. And so you didn't go back necessarily to stay with the family, but just because your friend wanted to see the East Coast. And this was a place where you could live while doing that. And I had told her of my stay there in 76 and you wanted to spend some time with the Menendez family. Uh-huh. Is that correct? Yes. And Jose and Kitty Menendez put up you and your friend in 79. Yes. So they're just wonderful people that would never abuse their kids, right? Because they allowed someone to come stay with them. I mean, get real. You're trying to connect the two different scenarios. It's not the same. And as they had put up your sister back in 76, they put up the friend, like the sister. Yes. Did any other members of your family stay with the Menendez family? Are you referring to my brothers and sisters? Yes. No. Now, what was your reason for going back in 82 and 83 and living with the Menendez family for a full year? Because I thought it would be similar to my prior year's experiences. Were all of those experiences good? The 76 was very good. 78, we were very busy, and I don't recall really either way how I felt about it. Well, it was good enough to cause you to want to go back in 79. Right. Objection argumentative, overruled. Is that correct? So so would you, oh, she says yes, sorry. Next question. So would you say that the experience in the 4 months in 78 was a good experience? Yes. And then the 2 weeks that you stayed there with your friend in 79, would you say that was also a good experience? Yes. And you still felt good about Kitty and Jose Menendez after 1979? It had changed, but not at all like it was in 82. Yes. I'm sorry? The dynamics changed, but not at all like it was in 82 and 83. You're saying by 79 it had changed? Yes. What I'm saying is by the end of the 76, after the 2 week stay, you still felt good about Jose and Kitty. Is that correct? Yes. And you had not been, or you had not seen anything up to that point that had caused you to have any resentment or bad feelings about them. Is that correct? In general, I guess the answer would be no. But technically, like if you see some people Like if you start to see their true colors and you don't like them, sometimes it's gradual, but it takes a few multiple opportunities for it to s- in order for you to start to become aware of it. Mr. Khan asks, okay, and that stay in 76, that was a time when Eric Menendez was about 8 years old. Is that correct? Correct. And Lyle Menendez was about 11 years old. Is that correct? In 79? In 78. In 78? Right. Eric would have been 7, I guess, and Lyle 10. There was nothing about the 4 months of that summer that caused you to have negative feelings about Kitty and Jose. Is that correct? Not to the extent that it occurred in 82, 83. No. I'm just asking you about what were your feelings about Kitty and Jose Menendez by the end of the summer of 78. They were okay. Okay, and you told your friend Karen, let's go visit my aunt and uncle because they're okay. Is that correct? Mhm. Now, what were your duties? Did you have chores and duties that you had to do in the summer of 76 and 78? Yes. What did you have to do? Which are you referring to? Well, did the duties change between 76 and 78? Yes. In what way did they change? Well, they were entirely different. Why is that? Just our situations were different. They were in the process of building a home. I was working part time at Kitty's carpet cleaning business, and the dynamics of the summer were just different. Kitty had a carpet cleaning business? Okay, I didn't know that. So, what were your chores in 76? Well, cleaning the house, of course, and I watched the boys a lot. I spent a lot of time watching the boys and taking them to the swimming pool where Jose would then meet us. Uh huh. How often did you take them swimming in 76? Quite often. What does that mean specifically? Several times a week. Uh huh. And did Jose Menendez, wasn't Jose out of town a lot? On the weekend more than during the week. It's kind of vague as to 76. Uh-huh. Well, during 76, when you would take the defendants to the swimming pool, did you normally take them during the week or during the weekend? I would take them during the week. If Jose was home on the weekend, Jose would be taking them. Uh-huh. And when you took them to the pool, when I took them to the pool, it was with the understanding that Jose was going to be meeting us. Was it always with that understanding? To the best of my recollection, yes. Okay, and what will the defendants would the defendants be swimming before they arrived, or would arrived before they started swimming? They were instructed to do laps. My question is, would the defendant swim? That's swimming. Would the defendant swim before Jose arrived, or would doing laps is swimming? Okay, my question is, did the swimming start before or after Jose would arrive? In my mind, swimming laps is synonymous to your question. You would take the defendants to swim, is that correct? Yes. Was Jose Menendez at the pool when you got there? No. What would happen until Jose Menendez got there? Their warming up was to swim laps. So they would start swimming without Jose Menendez, is that correct? Correct. And you would watch them do the swimming. Correct. Did you tell them not to horse around in the water or play or have fun in the water? No. What would the defendants do? Just swim laps? They were warming up. Is that what they would do? Just swim laps until Jose Menendez got there? It was routine. Okay. How many times did this happen during 76? Regularly. How many times did it happen in 76? I just know that it was a regular routine. I can't give you the exact count. Several times a week, each and every week, and every week that you were there, they were down at the pool, whether it was with me or without me. I'm just asking about when you took the defendants to the pool. Do you understand? Okay. I'm asking you, how many times did you take the defendants to the swimming pool in 76? I thought I answered that several times. The whole summer, it was only several times? No, a week. Each and every week you were there, is that correct? Yes. Duh. And each and every week that you did this, would it be always under the same circumstances where Jose Menendez was not there and they would swim laps until Jose Menendez got there? I don't recall ever going to the pool without there being a purpose for that, if that's what you're asking me. I'm not asking if there was a purpose. I'm asking a specific question that is, are you telling us each and every time you went to the swimming pool, precisely the same thing would happen? The defendants would get in the water and swim laps until Jose Menendez got there? I don't recall. You don't recall whether or not they played in the water until their father got there? No, I don't. And you don't recall how many times Jose Menendez would get there as opposed to Kitty coming in his place? How many times? Yes. No. And you don't. Ms. Amerson says, I'm going to object and move to strike. Assumes facts, not in evidence, overruled. Mr. Conn says, and you don't recall how many times you just watched them by yourself and took them home without Jose Menendez arriving. Is that correct? That didn't happen. That never happened. Is that correct? Uh-huh. No. Now, you observed Jose Menendez doing breathing exercises with Erik Menendez. Is that correct? Correct. Was this just in 76 or in other years as well? I remember it in 1976 at the Ramapo pool. I don't know if I saw them swimming in 78. Okay, how often did you observe Jose Menendez do these breathing exercise with Erik? It was a regular routine with him. How often did you observe Jose Menendez holding the head of Erik Menendez under the water? As often as I saw him work with the boys on their swimming. So you're saying that each and every time he would hold the head of Erik Menendez under the water until Erik Menendez would cry? It was part of their drills. Crying. Crying? That's the question. Crying was not part of Jose's drill. My question is, are you saying that each and every time you saw Jose Menendez with Erik Menendez in the swimming pool, he would hold his head underwater and he cried? Or until he cried? I don't know if his purpose was to hold his head underwater. Well, I'm not asking his purpose. Ms. Abramson says, could the witness answer? The court says, all right, do you remember what the question was? If not, you can repeat it. The witness says, thank you. The court says, why don't you repeat the question? Mr. Conn says, yes. My question to you is, are you saying that each and every day you saw Jose and Erik at the swimming pool, Jose would hold his head, Erik's head, underwater until he cried? What I'm saying is that each and every time that Jose was in the pool with the boys, he had a routine that he did regarding training sessions for swimming because he was a fantastic swimmer, Olympic-like swimmer himself. Did anybody actually ever see him swim? Is that even true? Or was this his dad made him swim when he was young and now he's making his kid swim? But anyways, and that he had a routine that he worked on with the boys, and that was part of it. I doubt Olympians are trained with their heads being shoved underwater until they cry. I don't think that's part of their protocol. My question is, how often did you see Jose Menendez hold Erik's head under the water until he cried? As often as he worked with the boys in the pool. So, every time he was in the pool with them. So you're saying every single time you saw him in the pool with the defendant, he would do this? Is that correct? Yes. And every single time Erik Menendez would cry. Is that correct? Oh gosh, I don't know if Erik cried every single time. No, I don't know that. Sometimes he would cry and sometimes he wouldn't. Is that correct? I suppose. And you saw him pull the feet of Erik Menendez down to the bottom of the pool? Yes. How deep was the water? I don't know. Well, did you happen to see Jose swim way down below the surface to get to the bottom of the pool, or was it a couple of inches over the head of Erik? If he were standing, it would probably be about his height. Whose height? Not even, because it was about a 5-foot pool because I was taller, so 5 feet, 6 feet. So the pool water was 5 or 6 feet deep. Is that correct? Is that correct? I guess so, yes. And how big was the swimming pool? It was a large public pool that was no deeper than 5 or 6 feet any place. Is that what you're saying? I don't recall. Well, I'm asking about how he used to supposedly bring him down to the bottom of the pool. Did he have to swim down to bring him down to the bottom of the pool? I guess it depends on your definition of deep. Oh, that's what I'm asking you. How deep was the pool? Deep enough so when he pulled Erik under, he was under the water. You don't know whether Jose Menendez had to swim himself to bring Erik Menendez to the bottom of the pool. Is that correct? What difference does it make? He's dragging him under the water where Erik can't breathe. So it doesn't matter if Jose gets there or how Jose gets there. She says, I don't recall. And then when this was over and Erik Menendez would come to the top of the water again, he would be gasping and crying every time. Objection, misstates her testimony. Overruled. What's your answer, says the court. The witness says, would you repeat your question, please? Mr. Conn says, are you saying that each and every time Jose Menendez would then let him come to the surface, he would be gasping and crying? When he pulled Erik to the bottom of the pool while he was training him to keep his feet together? Yes. Then yes. And each and every time you would see Erik Menendez gasp and cry. Is that correct? Gasping. Is that correct? Gasping, yes. Yes, you would see this several times a week throughout the whole summer. Is that correct? Yes. And you still felt very good about Jose when that summer was over. Is that correct? I said that I felt very good about Kitty. Didn't you tell us a little while ago that the reason why you brought your friend in 1979 and the reason why you went back to spend the full year with the family in 82 and 83 was because you still had good feelings about Jose and Kitty still? Objection, misstates the testimony. She said okay. She was okay with them. Overruled. Your answer? My relationship was with Kitty. I was very intimidated from the very beginning by Jose, always. Uh-huh. I hate this. He was doing this with other witnesses in the past. Uh-huh. Like, almost like, I don't believe your answer. Uh-huh. But you felt good enough to bring your friend over to stay a couple weeks in the home. Is that correct? I didn't say that. Well, did you feel I have? Did you have any problem with bringing your friend to live in this home for a couple of weeks? Objection vague. Sustained. Did you have any reservations about bringing your friend to stay in his home for a couple of weeks in 79? It wasn't about how I felt about Jose, it was about how I felt about Kitty. Well, didn't you tell us a little while ago that you felt okay about them by the time that you brought your friend back in 79? Yes. Okay, and that's because you observed no behavior on the part of Jose prior to that that caused you any concern. Is that correct? What I'm telling you is routine, and that was Jose, and I didn't question Jose ever. My question is about your feelings towards him. The reason why you had no problem bringing your friend over in 79 to live in his home for a couple of weeks was because you observed no behavior on his part prior to that time that caused you any distress. Is that correct? Objection argumentative. The court says overruled. The witness says any distress regarding what? Any distress, says Mr. Conn, about bringing your friend to stay under his roof. If we're referring to the swimming, yes, I recall it as being way beyond what I had seen people do as far as practicing sessions with swimming, but he was supposed to be the guru of swimming. Mr. Khan says, and what conclusion did you reach? In light of the fact that he was supposed to be the guru of swimming, what conclusion did you reach at that time that you would observe this behavior? Objection, Your Honor, says Ms. Abramson. The court says it's vague as to what you mean. Mr. Khan says, what was your feelings? How did you evaluate what you had observed? I did not evaluate Jose. Well, what were your feelings about what you observed in regard to the way that he was training Erik? It was never a part of my mindset to question Jose. So you just let Jose do he's the adult, like you're the teenager. Why are you going to question the adult, right? They're not going to listen to you anyways. What were your feelings when you saw what you are telling the jury? Let me finish the question. When you saw what you were telling this jury you supposedly saw back then, what were your feelings about what you were watching? My sister Kathy and I, while he was working with the boys, would be off doing our own things. He was with the boys, and I never questioned Jose. Because you never watched him training the boys, is that correct? Excuse me? You never watched him training the boys, is that correct? That's not correct. Then when you would watch it, what would your feelings be about the way he would behave towards his son, Erik? That it was way above and beyond what my experience was, what I had seen. Did you conclude that this was some type of wrong behavior on his part? He had very he had reasons, verbal reasons why he was doing this and never questioned him. Well, I'm asking you about your conclusions regarding his behavior. Did you conclude that this was some wrongful behavior on his part? I wasn't making those kinds of conclusions at all. Then. She's a teenager. She's not really paying attention to it. Like, she sees it, she notices it, but she's not thinking, like, oh, I better step it. Or, like, she's not going to step in and talk back to Jose because nobody did. What makes you think a teenage girl is going to have any success when other adults tried and couldn't reason and talk to Jose? So you didn't say to yourself, wait a minute, this is wrong. Listen, mister, she says. He says, let me finish. Miss Amerson says, excuse me, let him allow the witness to answer the question. The court says he hasn't finished the question. She sort of jumped in. Mr. Khan says, did you conclude in your own mind this is wrongful behavior? What this man is doing is wrong. Did you conclude that at that time? I concluded, at the most, that it was different from anything I had seen. You did not conclude in your mind that you were observing any type of improper behavior. Is that correct? Would you repeat the question? You did not conclude at that time that there was any type of improper behavior. Is that correct? Jose said it was okay. I did not question him. You were 17 years old at the time. Is that correct? Okay. And at that age, you reached no conclusion in your mind that this behavior was wrong in any way. Is that correct? Sir, I have never questioned Jose. I'm just asking you about your conclusions. Ms. Abramson says, Your Honor, this has been asked and answered now. The witness says, that was my relationship in that household. I did not question Jose. The court says, it's not a question of questioning him. The witness says, if I'm not questioning what he's doing, the court says, wait. The issue is, did you think about it in your own mind? Not did you question Mr. Menendez? Did you think about it? I thought about it to the extent that it was very different from anything that I had ever encountered, and Jose was telling the boys precisely why he was doing what he was doing, and I left it alone. If I'm not questioning a person, I'm not drawing conclusions either. Mr. Khan says, and you gave it no further thought? And I gave it no further thought. Is that correct? Well, I must have given it some thought because I recall it. Well, I'm asking you, do you evaluate it further in your mind or as to whether this was proper or improper behavior? It was never on my mind to evaluate anything Jose did. But don't you have impressions when you observe things in the world as to whether, well, let me finish the question. When in your own mind something is right or something is wrong? This man was so above me in my mind that it wasn't even part of what I would have done. Well, did you watch the trial? Did you watch the first trial on TV? Excuse me? Did you watch the first trial on television? Part of it. Did you watch the testimony of Erik and Lyle Menendez? Part of them. Okay, as you were observing their behavior, did you ever call over a lifeguard and tell a lifeguard that child in the swimming pool is in danger? No. Did you ever go back and report to your mother, Joan Vandermolen, at the conclusion of your summer vacation in '76 that you had observed something that you regarded as improper? I never shared with my mother a lot of things that I observed in that household. So you didn't make any such reports, is that correct? Correct. To your mother or to anyone else, is that correct? Correct. Now, during the '78 visit, what were your chores and responsibilities? I was working 20 hours a week at Kitty's carpet cleaning business. I took care of the house and helped with the boys a lot and mowed the lawn, things like that. Were you happy to be there to perform those functions? Yes. Did Kitty Menendez give you a job? Yes. Did you see any other cousins staying at the Menendez residence during that time, during any of the periods that you were there? Any of them? Yeah. I saw Andy Cano stay. All right. The Baralt children were in and out, but not to stay. How long did you see Andy Cano stay there? He was there for a couple of weeks at one point, and then they moved to the same area where the Princeton area. Can't remember. Did Alan Anderson ever stay there while you were there? No. We were never in the house at that time. Did you say your grandmother lived there for a while? She was convalescing, I think is the word. Is your grandmother you're referring to what is her name? May Anderson. How long did she live at the Menendez home? She had a lot of health problems and she went there after I had left in '83, sometime in the fall of '83 into '84. Do you know how long she lived there during that time period? Several months. Now, you said that when you would take a different swimming, when you would take the defendant, when you would take the defendant swimming, did you ever observe any bruises? When you took the two defendants, when you took Erik Menendez swimming, did you ever observe any bruises on his body? I don't recall. The entire summer, you don't recall any bruises on his body? No. When you visited the home in '78, stayed there briefly in '79, and during the year of '82 and '83, did you ever observe any bruises on the body of Erik Menendez? I don't recall. Now, you said that Kitty Menendez would become rageful at times. Is that correct? Yes. And when did you first begin to notice rageful behavior on the part of Kitty Menendez? In the '78 visit, it was beginning. By '83, it was just beginning. As far as I recall, by '83, it was in my mind full blown and happening all the time. Well, so how many times did you see it in '78? The '82, '83 visit was so traumatic for me that it's kind of a blur as far as what happened in the '78 visit with regards to that. '82 was so traumatic for you that '78 is a blur? In reference to how her rages were in '78, to define the intensity of them, it's a little difficult. I'm not asking you to define the intensity. I'm saying, how often did you see these rageful behaviors in Kitty back in '78? It wasn't at all with the frequency that it was in '82. That's all I can tell you. Well, but give us approximately how often we're talking about here. I wasn't keeping track. I mean, I wasn't. All I can tell you is it was not at all the frequency that I observed. Was it closer to once a month or once a week? Objection, Your Honor, calling for speculation. Overruled. You may answer the question. God, it's tough for me to say. I don't recall. Mr. Khan says, so you can't give any estimate as to whether it was more likely once a week or once a month. Is that correct? About once a month, once a week. Okay, so when you would see this behavior, I'm just talking about in 78, a weekly behavior of rage on the part of Kitty Menendez. Tell us what you would ordinarily see. In 78? Yes. In 78, there was a lot more of throwing things around. It hadn't reached the full blown out. Well, what do you mean by that? Not full blown? In 82, 83, when she flew into a rage, it created fear to your core. And in 78, excuse me, in 82, 83 is what I'm referring to. In 78, it was more like a very deep frustration. A deep frustration on the part of whom? Kitty. What behavior would you observe in 78? The weekly occurrence that you would observe in 78. What did that consist of? Yelling. She was still going, I'm sorry, she was still doing these clenching fist things that she was doing in the air, like, rah, I hate you, with her fists clenched, and you'll rue the day you angered me, type of thing. So to the intensity that it was in 82, 83, it wasn't to the intensity. Throwing dishes and being in the kitchen, just throwing her head around and yelling while she was doing it and yelling out whatever. She wasn't doing that in 78? Yes. She was doing it in 78? Witness nods. What was the difference between 78 and 82? It's really tough for me to describe, how intense her rages were. Well, I'm not asking you how intense they were. You just asked me what the difference was, and that's the difference, is that it was just, I feared. I didn't know what was going to happen. In 82? 82. In 78, did you fear her because you didn't know what was going to happen? No, it was just a lot of anger. Uh-huh. She just was really angry and really frustrated and just losing it. Okay, and what would provoke this in 78? I'm recalling things to do. Things were getting done for the house that they were moving into in Pennington. If something went wrong to do with that would create it. It's hard for me to recall exactly what would trigger it from 78. You can't recall something else from this point in time? Uh-huh. So it was nothing her sons did in 78. Is that correct? I can't answer that either way right now. Well, then how often was her rages in 82 that you observed? How often? Yes, a few times a week. So she went from about once a week to a mild rage, throwing things and things, but now she's in a serious rage and it's multiple times a week and she's violent and angry and scary. Did that begin as soon as you arrived or did it build up after you had stayed there for a while? No, it started. It started shortly after I got there. You stayed there for 13 months, is that correct? Correct. Watching this a few times per year, is that correct? Yes. After watching it for the first month, did you say, I feel so uncomfortable about this that perhaps I shouldn't stay here any longer? Actually, sir, I was feeling rather helpless. Uh-huh. And I was closing in and staying in my room and becoming afraid of every step I took and trying to figure out some way to please her. You were, I was, then what? Great dialogue. Um, this was someone, says the witness, who I had a very close relationship with and was trying desperately to find a way back to that and was unable to do so. You were 23, 24 years old at this period of time. I was 23. I think Kitty needed some serious mental health treatment that she wasn't getting. She would really have to admit that things were wrong in order to get proper treatment and she didn't admit things were wrong. She had a therapist we know of, but what the therapist knew and if she ever even admitted to the therapist that her husband was doing the things that he was doing to their sons, then maybe we would have had a different story, but she obviously didn't because it wasn't in the testimony, right? So how are you going to get proper treatment and heal if you're not even telling your therapist the truth about what's going on in your home, which is causing you to have all the stress and anxiety and crazy rages that you're having? Anyways, so you were 23, 24 years old at this period of time. I was 23. And that was not your mother, that was your aunt. Is that correct? Yes. You hadn't visited the family in 3 years. Is that correct? Yes. What were you doing those 3 years between the ages of 20 to 23 when you were not with the Menendez family? Your Honor, I'm going to object to that as irrelevant. 35352. The court says, what do you mean? She was living at home, going to school. Yes, says Mr. Conn. Were you living at home or going to school during that time period? I went to school part time at community colleges in Arizona. Yes, I was living in Arizona to answer your question. Were you working at that time period? I was working also full time, going to school part time. And then you went back to the Menendez home in 82. For what purposes? Because I anticipated it being continuing the relationship that I had with her from 76. And then after you arrived, you began to notice immediately after your arrival that Kitty Menendez was now engaged in these full blown rages 2 or 3 times a week, virtually from the time of your arrival. Is that correct? That's part of the change, yes. Okay, and then you immediately felt helpless and unable to take a plane back to Arizona? I had come there fully expecting to live back east for quite some time. I loved Kitty and I was trying desperately to make something work. Well, are you finished? No, I'm not. I was unbelievably unhappy, sad, feeling helpless by Christmas and determined that I was going to get myself out. But it wasn't in my mind at the time to get myself out other than to get myself out of the house. Well, when you said that you felt helpless after you arrived back there, and again, seeing these rages on the part of Kitty Menendez, what did you mean by that answer? You didn't know when they were going to happen, what was going to create her flying off into a rage, unable to do enough. So you can't stop it. So why didn't you just leave? I had been very close to her and loved her very much, and I was trying desperately to please her. If you were so upset by these rages, why did you want to please her? I loved her. What did you do to help her deal with these rages? I tried to reason with her a few times. It did not work. And you were afraid for every step that you took. Is that correct? You bet. Why were you fearful? Mr. Khan says, I'm sorry, she says, Mr. Khan, she attacked everything about me in her rages. Everything about me. You were fearful that she was going to hurt you? You want me to? That she was going to hurt you? Yes. That she was going to physically hurt you. Is that correct? Yes. When did you start to believe that Kitty Menendez was going to physically hurt you? In the middle of her telling me that, yelling, screaming at me, that she was perfectly capable of marching me downstairs and throwing myself and my belongings out on the street, not caring that I was related to her, and that if I had come up at any time prior to being in her presence, that she would have done so, and she doesn't give a damn about me or who I was or what I was about. Nasty woman. When did you begin to become fearful of her? So Seems like, when she gets angry or whatever and she's in these rages, she says the things that she knows are going to be the most hurtful. Like, I wish you had never been born. You ruined my entire life, kid. To, I don't give a damn about you. Sounds like she went to like the most hurtful insults and comments after she was at her point of no return when she was in her rages. When did you begin to become fearful of her that she might hurt you? When she started getting into my face with those exact same words. How soon after you arrived did you become fearful of Kitty Menendez? Did I become fearful of her? Yes, the fear that she was going to hurt you. Her approval of me meant everything, and this started early on and it started going downhill really quick like that. My question is, how soon after you arrived in 82, after not seeing her for 3 years, how soon before you arrived back in 82 did you become fearful that Kitty Menendez was going to hurt you? Whenever that conversation took place, it was about halfway through, I'd say November. After you had been there for about how many months? I arrived in June. So by November, she's already pretty miserable. Okay. So when by November, did you then decide, well, it looks like I try my best with my Aunt Kitty. I think she is going to hurt me, so perhaps it's time for me to take a plane back to Arizona? Are you asking me what I did? I'm asking you if you had that thought in your mind. Actually, I started writing letters about my final goodbye, Mr. Conn. He says, you became you wanted to take your own life because of the way that Kitty Menendez was treating you? Yes, Mr. Conn. That's the effects of abuse. When you feel helpless, stuck, nothing you can do is ever right, and they put you in like the lowest low for your own self-esteem. They cut it down as much as possible over and over again until you think you're nothing, and that's a very serious side effect of abuse, not talked about nearly enough. Um, yes, Mr. Khan, she says. Why did you not just get on a plane and take a plane back to Arizona? Because I loved her, Mr. Khan. Well, why did you stay to put up with that? Because I was trying to get back that relationship that I had in 76, Mr. Khan. What were you fearful? What were you fearful that Kitty might do to you? Anything she wanted. Physically, did you feel? Physically, emotionally, anyway, you name it. How did you feel she was going to hurt you physically? To have a person yelling and screaming at you and coming clear across the room into your face with her arms out to hear, demonstrating, hear her teeth gritting at you and yelling every single solitary thing they're telling you, that's why I felt that way. Did you feel she was going to kill you? I felt myself disappearing. What do you mean by that? It took everything within me to get myself back together enough to continue, and I'm still trying to get my self esteem out from the gutter, Mr. Khan. Ooh, so Kitty did a number on her that final year. Because of the way that Kitty Menendez treated you? Yes, Mr. Khan, because she meant that much to me. Because she started crying, I'm sorry, because she started coming on to you that way in 82, you saw yourself as if you were in the gutter? I felt worthless. Yes, Mr. Khan. Did you ever say to yourself, if Kitty has a problem with, it's time for me to move out and recognize that this was her problem, not mine? Mr. Conn, I adored this woman. She was someone I looked up to always and thought that it must be my fault why this was happening. My mind didn't work that way. She's still a young, impressionable, young adult at this point in time. So let's not forget that. It's still, you still don't feel like an adult at 18 years old necessarily. And you definitely aren't by, definition. It's just you don't have the life experience yet, and that's okay. But anyways, my mind didn't work that way, she says. So you thought that way even when you were 23 years old, is that correct? Yes, Mr. Khan. So did you feel that perhaps she would kill you? I felt that perhaps I would kill myself. That's all I remember. And never that she would hurt you? I didn't say that. Well, did you feel that she would kill you? That's what I'm asking. No, there's a difference between her hitting and killing me, Mr. Khan. Well, that's what I'm asking you. If you recognize that Kitty Menendez, excuse me, if you didn't feel that she was going to kill you, I felt that she was going to hurt me, and she did hurt me. Hurt you in what ways? Not physically, emotionally. But she never hurt you physically? How do I put this? Where it was at a point where I was in fear of her doing that quite often, yes. What did you think she was going to do to you? That's part of the unknown. That created the fear in me. Did you think she might use a weapon against you? That never entered my mind. That you felt that she might use her hands against you? Yes. And you never thought that she would use more than her hands against you, is that correct? I didn't rationalize it that way. I was just in fear of her at the time. That's all I knew. So, how much longer were you planning on staying with the Menendez family by November when you felt that you were in danger from Kitty? I was praying nightly that God would give me a way out. You felt that you didn't have a way out at that point, correct? Why did you feel that there was no way of the Menendez home or no way out of the Menendez? Why did you feel there was no way out of the Menendez home when you were 23 years old and just visiting from Arizona? Because I felt very much a part of that household. I felt that everything in me when I arrived was wanting it to work. Is there a part of the question that I'm not answering? Your next question, please, says the court. Yes, says Mr. Khan. So when Kitty would go into these rages, how many times were the rages directed at you rather than at her sons? The rage would be directed at any of us. Well, I'm asking, how often was it directed at you rather than her sons? I didn't keep a tally, Mr. Khan. You didn't? It happened a lot, and you never knew when it was going to set off. Okay, I'm just asking you if you can guess an estimate of the time of the number of things. Nope. Start over. I'm just asking you if you can give us an estimate of the number of times it was directed at you rather than her sons. It was directed at whoever happened to be there when it was happening. All right. And you can't give us an estimate, is that correct? It happened a lot, all the time. These they happened quite frequently. And I was often there in the household, either observing it happening at somebody else or having it happen directly at me, at my face. Okay. And so, what made you finally leave the Menendez home after 13 months? I met someone at a church who offered to be my roommate, and we were able to do so. And we thanked God that he had brought us together. So you moved out of the Menendez home once you found a roommate, is that correct? Yes. Thank you. I have no further questions. The court says, any redirect? Oh, a few, says Ms. Abramson. So we are back for some redirect. Ms. Abramson says, you think Detective Zoller coming over to you yesterday was to set you up? Yes. Objection, says Mr. Conn. The witness says, I believe so with all that's in me. Ms. Abramson says, you've been sitting in Denver and in. I have been available to talk to anybody since this all began. I lived in Denver for 5 years. I did not keep myself hidden, and I'm now in Arizona. And you know we turned over interviews of you to the prosecution about what you were cross-examined about at the last trial, don't you? Objection. Calls for speculation, says Mr. Conn. The witness says, yes, I do. Sustain. The answer stricken. Miss Amerson says, did you ever ask us to keep your address or telephone number a secret from the prosecution? No, it was published. And you've never been called by any of them? I've never been approached by ever by anyone. And concerning the first trial, you testified in that trial concerning your observations of the behavior of the Menendez family, correct? Yes. And you testified about the same topics and more than what you testified to here, correct? Objection irrelevant. Yes, I did. Overruled. Objection irrelevant. Motion to strike. Overruled, says the court. Ms. Abramson says, and when you testified in that trial, you were the first witness for the defense in that trial, were you not? Ms. Abramson says, the second witness for the defense, were you not? She would not know, says the court. The witness says, the fourth. The court says, the answer is stricken. Ms. Abramson says, you testified very early in the case, in the defense case. Yes. Did Erik and Lyle Menendez testify weeks after you did? Yes. So, at the point when you reached portions of their testimony, you had already given your evidence, correct? Yes, I had. And you had been interviewed, had you not, in June of 1991 by Miss Lansing, Lyle Menendez's former attorney? Yes. And you had been interviewed in January of 92 by Ms. Lansing and myself. Correct. Were those extensive interviews concerning your observations of the behavior of Kitty and Jose towards their children? Yes. And that was a year and a half before the first trial began? Correct. Ms. Vandermolen, do you have emotional scars you believe stemming from the feelings that were engendered in you by what you perceive to be Kitty Menendez's betraying your love and trust? Yes, I do. Has it always been painful for you to talk about her and the way that she treated you? Very much so. Is one of the reasons why you thanked God that you found your roommate in church because she was destroying you as a person? Yes. And shortly after you left her home, was she trying to persuade you to have uh one of those things that I don't want to say on the air 'cause I don't know if you can on YouTube. Um she didn't try to persuade me. She told me that I owed it to Jose and was demanding that I do so. Would that have been your 11-year-old son? Correct. And was the reason why you were only allowed to come back to the house and visit your grandmother when no one else was around because she was keeping the fact that you, at 24, were pregnant a secret? She forbade me to speak to anyone in the Menendez family, forbade me to be at the house if there was a possibility of Lyle and Erik being present, because under no circumstances was anyone in that household, including especially Lyle and Erik, to know about what that I was pregnant. And in fact, was the first time you ever discussed the fact that you were pregnant that year and had a child with Lyle and Erik Menendez when you saw them at the memorial service? The first time that I ever spoke to them again was at the memorial service here in California, and that was the first time that they learned that I had a son who had been born there in Princeton. Were you very religious when you were 23 and 24? Yes, I was. I went to church every Sunday. And did Kitty Menendez mock you and humiliate you because she was an atheist? Both Kitty and Jose laughed at me because I believed in God. Now, did you, when you, hold on. Now, did you, when you first went to live with them in 76, had you been given an impression of them and a sense that they were extraordinary somehow from your own family, from your grandmother and other relatives? My grandmother May, who worked with United, so she was able to come out and visit quite often, would bring pictures of when Kitty had won the Oak Lawn Beauty Contest, and she would talk about Jose's family and that they had come from this father had been. I object. Calls for a narrative at this point. Court says it's also non-responsive. The answer is stricken. Saberson says you can answer yes or no. Okay, yes. Did you hero worship them? Yes. Were you extremely flattered when Kitty Menendez invited you and you only to come spend the whole summer? It meant everything to me at the time. And later, was your sister Kathy included in the invitation? Yes. Was Kathy's reasons for leaving because she was feeling so destroyed by the way Kitty treated her in 76? Yes, it was. Objection calls for hearsay, says Mr. Conn. The court says objection sustained. The answer is stricken. Miss Amerson says, did you observe your sister Kathy become increasingly depressed and unhappy over the course of that summer in 76? Objection, leading. The witness says, I definitely did. The court says, objection overruled. Miss Amerson says, do you believe that you were treated better by Kitty that summer than Kathy was? I'm confused by your question. In 1976, do you believe that your Aunt Kitty treated you better than she treated Kathy that summer? There was a huge difference between the way we were treated that summer. And by the time you had reached that point in November of 82 when you wanted to take your own life, were you being treated in a similar way to how Kathy had been treated in 76? Yes. Did you believe, well, first of all, that summer of 76, did your Aunt Kitty Menendez spend a great deal of time with you? In 76, yes, Kitty did, yes. Was she positive and supportive in the way she talked to you that summer? Exactly, which is a lot of why we bonded. Were you an insecure teen? Yes. Uncomfortable with your looks? Yes. Did she put you on a diet? Yes. Did she introduce you to your first boyfriend? Yes. Did you look like her? Yes. Is there a strong resemblance between the two of you? People thought we were sisters. Did you want her approval? With everything that was in me. Did you want to be like her? For a long time. Was she warm and affectionate and loving towards her children? No. Objection beyond the scope. Overruled. Was she warm and affectionate and loving towards you towards you? In 76, yes. Did you care, therefore, how she treated her children at that point? My focus wasn't there. It was on me. You were being selfish? Yeah. Did you ever like Jose Menendez? He laughed me out of every single conversation. To whether I liked. The court says, the question is, did you like him? Did you like him? Says Ms. Abramson. I was in awe of his power in his presence. He controlled every room he was ever in. Was he charismatic and charming? Yes. Were you told that he was a genius and wonderful? Yes. Was he making a lot of money? Yes. Was that a big deal in your family? Yes. Was he the big success? Yes. Did he claim to be incredibly knowledgeable about everything? Yes. Objection irrelevant beyond the scope, says Mr. Conn. The court says, sustained to the last question, the answer is stricken. Ms. Abramson says, you, as an insecure teenager, would you ever think of challenging anything Jose Menendez said? Objection, argumentative and leading. rephrase the question, says the court. Ms. Abramson says, did you ever give your own sense of yourself and confidence or lack thereof? Did you ever consider challenging Jose Menendez on anything? No. Did you ever think of doing that at 23? No. Could you understand why his little children never challenged him? Yes. Objection irrelevant. Sustained. The answer stricken. Was he nice to you? No. How was he not nice to you? Objection irrelevant. Evidence code 352. Sustained. Was he belittling and humiliating and sarcastic to you? Objection leading, suggestive, and evidence code section 352. Sustained. Did he treat you similarly to the way he treated Erik Menendez? Yes. Did you have a positive feeling about yourself as a consequence of the way you were treated by Mr. Menendez? I felt like an idiot. Objection irrelevant. Overruled. The answer will stand. In 1978, you indicated that the pace of life had changed around the Menendez home? Yes. You said that you were very busy. Right. Was Mrs. Menendez very busy? Very busy. Was the organization of the home somewhat chaotic at that point? Yes. Objection. Evidence code section 352. Overruled. Abramson says, did you spend as much time alone with the children in 78? No. You said you were working 20 hours a week in her carpet cleaning business? Yes. Did she pay you? Yes. How much? Objection irrelevant. For something, says the witness. The court says, objection sustained. The answer stricken. Minimum, says Ms. Abramson. Objection, says Mr. Conn. Sustained. Doesn't really matter. Ms. Abramson says, did she work in her carpet cleaning business? Objection irrelevant. Overruled. You can answer the question. I'm sorry? Did she work in the business that summer? Yes, she oversaw a lot. In addition to working 20 hours a week in her carpet cleaning business, were you required to clean the house? Yes. With her or instead? Instead. So you were the housekeeper? Correct. Did you babysit the children at night? Yes. Were there other babysitters or was it just you? No, I was it. Did you do the yard work? Yes. In addition to other members of the family, or were you out? Were you it? No, I was it. Before you got there that summer, did they tell you that they were going to be the gardener, did they tell you you were going to be the gardener, the housekeeper, and the babysitter? No. Were you treated with the same solitude by Ms. Menendez in 78 as you had been in 76? No. Was it still tolerable? Yes. Did you love her? Yes. Did you still talk as if the two of you were sisters? Yes. Did you notice at this point any newfound expressions on her part of affection towards her children? Yes. What? In objection irrelevant. Sabinson says, I'm asking, you had indicated in 76 that there were no signs of affection. Were there any in 78? Objection irrelevant. Overruled. Evidence code section 352. Overruled. You can answer the question. The witness says, please repeat the question. Generally speaking, was Kitty Menendez demonstrative towards her boys with affection? With affection? No. Did that ever get any better? No, it got even worse. In 76, was there some sign of positivity on her part towards Erik Menendez? Yes. Had that disappeared by 82? Yes. Were you still trying at 23 years old to make her happy and make her love you? Yes. Did you and Erik Menendez in 1982 have conversations where he asked you what could he do to make his mother love him or happy with him? Yes. Did you share that you were having the same problem? Yes. Were there ever signs from Kitty Menendez towards Erik Menendez of her approval to any degree? When she smiled towards Erik, yes. Well, there you have it. That was her show of affection. She smiled at him. And you've got her corroborating his testimony. What would cause her to smile at him? If he had just scored a point on the court, if he had if he had done something really well academically, which I guess basically it focused around either sports or academics. Performance. Performance, yes. So if he performed properly, she'd smile? Yes. Objection irrelevant. The answer is already overruled, says the court. Miss Abramson says, "Did you ever see anything else besides his mother's smile?" Objection. Aimed at that, aimed at him. Did you ever see another? Start over. Did you ever see anything else besides his mother's smile aimed at him that showed either approval or affection from her? We weren't allowed to have. Objection irrelevant. Evidence Code 352 and beyond the scope of cross-examination. Overruled. You can answer yes or no. Ms. Amerson says, "Did you ever see her do or say anything to him besides that occasional smile?" No. So if Erik Menendez testified the only positive thing he could remember was his mother's smile, that would be accurate. At 23, Ms. Vandermolen, oh, that would be accurate, she says, sorry. At 23, Ms. Vandermolen, do you think you were as vulnerable to be made to feel worthless as, say, an 8-year-old? Objection, calls for speculation, sustained. When you came back in 82 and 83, did you have chores around the house? Yes. What were you required to do? Continually clean the house. In addition to, or were you it? That was it. Well, there was a maid that came in half a day once a week. When you first got there, was the maid coming in twice a week? She was coming 2.5 days. And after you? When I first got there, and then she was cut back to half a day. So you were supposed to take over, right? Correct. Did you clean just 2 days a week or every day? Every day. And did you still have to do all the yard work? Yes, I did. I mowed all the lawns. I can't hear you. I mowed the lawn regularly, trimmed whatever needed to be done, things like that. What about school and work? I worked full time and went to school part time. So you worked full time, you were the housekeeper, you were the gardener, and you went to school part time? Correct. Were you asked by Mrs. Menendez or Mr. Menendez whether you were willing to be the housekeeper and the gardener and the babysitter when you were also working full time and going to school part time? No, I was just told what I was going to do. Were you paid for your housekeeping or babysitting or gardening duties? No. Were you putting yourself through school? Yes. Where were you working? I worked at an insurance company for a little while and then I went to work at RCA. Where were you going to school? I attended Rutgers University Summer School and I attended uh, Mercer County Community College. Now, Ms. Vandermolen, did you believe by the time you left that family in 1983 that Erik and Lyle Menendez were being treated properly by their parents? No. And specifically, was there some aspect of what was being done with them that you thought was wrong? When I look back, yeah, a lot. A lot. Why don't you just tell us briefly what that list is? Objection, irrelevant, improper opinion. Evidence Code, Section 352. Sustained. She answered as she looks back at it now, it's irrelevant. Ms. Abramson says, well, at the time, then, when you left, did you think that things were going on in that house that were wrong? Yes. Okay, tell us I know now you're a teacher, you're a mother, all the rest of it. But then at 23, what treatment of the children did you think was wrong? Objection irrelevant. Evidence Code, Section 352. Sustained. I'd like to be heard on that, Your Honor. It has to be tied up into something that was brought up in cross-examination. She says, okay. When you saw Jose Menendez holding Erik Menendez underwater at 7 in 1976 and the child crying and struggling, did that look cruel to you? I would never do it. Did it look cruel? At the time, it looked completely different, and now looking back on it, yes. At 17, did you feel adequate to challenge the great Olympic swimmer? Never. By the way, did you ever find out he was never an Olympic swimmer? Objection, irrelevant. Sustained. Did he claim to have been an Olympic swimmer? Yes. Objection, irrelevant. Sustained. The answer stricken. Your Honor, if we're going to take an afternoon recess, I'd like to do it now. The court says, let's see if we can finish this. She says, I don't think we're going to finish this. The court says, let's give it a try. Ms. Abramson says, you testified on cross-examination that you didn't share with your mother a lot of things that you said in that household. Do you remember that? Yes, I do. I didn't. Did you see a lot of things in that household that you thought were wrong? Yes. What did you see? Objection. Evidence Code, Section 352. Sustained. Mr. Conn asked you, Mr. Conn asked you if you thought Jose Menendez was okay or was good. Okay. Did you think he was a good person? I thought he was, it's a very hard question for me to answer because I thought he was very arrogant, cruel, and belittling in the way that he treated most people. Okay, dog, can you sit down, please? Mr. Khan tells her, let's focus. She says that he had this charismatic aura about him that also, it's just confusing. Well, let's talk about cruel vis-a-vis his children. Did you think he was cruel vis-a-vis his children? I said Mr. Khan, but this is not Mr. Khan. That's Ms. Abramson. I don't know why I said that. I got confused there for a second. Sorry. That was Ms. Abramson who asked the question. Um, did you think he was cruel vis-a-vis his children? Yes. Did you see him treat them cruelly? Objection, irrelevant. Evidence Code Section 352. Court says overruled. You can answer that yes or no. The witness says, please repeat the question. Did you see him treat his children cruelly? Yes. Was that beyond the swimming business? Yes. You said he was belittling. Yes. Did you see him belittle his children? Regularly. Objection, irrelevant. Evidence Code 352. Overruled. Regularly, repeats the witness. Ms. Abramson says, and you indicated you were personally intimidated by him. Very much so. Did you notice that his children were intimidated by him? Very much so. Objection calls for speculation. Overruled. The answer will stand. Ms. Abramson says, did you believe by the time that you were 23 and left his home that the principles, if you will, by which these children were being raised were wrong? Objection, improper opinion. Sustained. Do you believe that these children were being given any choices in their lives? Never. Objection, improper opinion. Sustained. The answer stricken. Did you believe these children were being dictated to? Yes. Objection, improper opinion. Sustained. The answer stricken. Did you believe these parents were cruelly dictatorial? I'll object, says Mr. Conn. I'll object to what counsel knows to be improper questions. You opined it, says Ms. Abramson. The court says, all right. Regardless of the colloquy between the lawyers, it's as phrased. The question calls for an improper opinion. The question is sustained. Ms. Abramson says, when during the last visit, when you began to feel very badly, was that based solely on how you were being treated or on things that you saw in the home? It was just everything, the entire atmosphere of that household. And what was the atmosphere? The portions of the atmosphere that you felt were bad, that were making you feel badly. So what was the atmosphere? Objection, irrelevant, overruled. You can answer the question. Please ask me the question again. What was the atmosphere? What was so bad about the atmosphere? The routine never stopped. There was never a pause. The rages that Kitty had, the frustration, and then the difference in who they were when no one was around and being told what we were allowed to say about what was going on outside of the house. There's enorm I can just go on. When you say being told what to say, was that because you were encouraged to keep secrets? Yes. Objection irrelevant. Evidence code 352. We were told to. Overruled. The answer will stand. You were told to keep secrets? Yes. Objection irrelevant. She's already answered the question. It's been asked twice now. Ms. Says the court. Ms. Abramson says, was any component of the atmosphere of that house pressure? Objection irrelevant. Evidence code 352. The court says again, it doesn't tie into the specifics of cross-examination, which is the purpose of redirect. Ms. Abramson says the things that you didn't share with your mother that you saw in that household that you found disturbing to you, okay, did any of it have to do with the pressure on the children? Objection, irrelevant. The court says that certainly is not a subject that was open on cross-examination what she didn't say to someone else. Yeah, she did. Ms. Abramson says, even in 78, Mr. Conn, did you go back there because you thought that everything they were doing in their family was perfect? No. When you went back there in 82, was it for personal reasons? Yes. To try to do something for yourself? Yes, exactly. You wanted to live in the East? Yes. You wanted to go to school there? Yes. You wanted to recapture it was it was reflective of something I had wanted to do since 76 when I was there, and everything was terrific that summer, and I thought then, Kitty and I began talking about it then. About you eventually going to college back east? Yes. So this was fulfilling this? Yes. Promise of the future? Yes. When you were there in 78, was the busyness of your schedule such that you didn't really spend that much time alone with Mrs. Menendez? Correct, yes. So you still expected that you might be able to recapture that earlier relationship? Yes. You testified that Kitty's rages were part of the change between, I guess, 78 and 82. What was the other major part of the change? Objection, vague and irrelevant. If there was any change, first of all, change in what? In the atmosphere, in the home. The witness says, Kitty, by 82, she just always seemed frustrated and angry at life. Just she couldn't keep up. It was just she couldn't find nothing was making her happy. Were there any changes in the way the boys were being treated at that point? Yes. Objection, irrelevant. Evidence code, section 352. The court says, I think this has already been covered as well. Ms. Abramson says, all right, Your Honor, I have nothing further. Any recross? Yes, just a couple of questions. Mr. Conn asks, when you went back in 82 and 83, was it Jose Menendez that got you a job at RCA? No, I got myself that job, sir. Did Jose have anything to do with RCA at that period of time? Yes. What was his connection to RCA? Objection, Your Honor. Based beyond scope and 350, 352. Sustained. Mr. Conn says, and you left the house, the home of the Menendez family, after you got pregnant, is that correct? Excuse me? After you got pregnant, you left the home of the Menendez family. Very, very, very incorrect. Well, were you pregnant when you left the home? No. You got pregnant after you left the home? Yes. When did you give birth to your child? June 13th, 1984. And when did Jose and Kitty Menendez begin to mock you and humiliate you? Jose started in 76. Kitty laughed at my belief in, or my faith and my belief in God in some time period, and also in 82 it was full-fledged, so maybe 78. And you became angry at the way that Jose and Kitty were treating you, is that correct? I did not become angry, I became desperate. And today you're angry at the way that Kitty and Jose treated you. Is that correct? No. You have no feelings about that? I have a lot of feelings about that. Anger? No. I have a lot of feelings in that I'm desperately trying to regain some self esteem, and I'm 36 years old. And you blame them for the loss of your self esteem? Yes. And this is your one chance to get back at them? What a ridiculous argument. You have no self esteem, so you're getting back at them at trial. No, you moron. She's telling you the truth of what she saw there. How about that? She says, I'm not getting back at them, sir. He says, I have no further questions. Anything else? And Ms. Abramson does have some questions. Do you believe in life after death? Never mind. I have nothing further. The court says, all right, thank you. You may step down. I guess she didn't have questions. He says, you're excused. We'll take a recess of 15 minutes. It may be a little longer depending on what issues I have to deal with the lawyers. But once we learn what the issues are and how long it'll take, we'll communicate with you whether or not we'll be able to resume the testimony today or pick up tomorrow morning. So we'll ask that you go to the jury room, and as soon as I learn what the schedule is, we'll have you back. The jury exits, and the following proceedings are held. The court says, who is the next witness? Kathy Simonton, says Ms. Abramson. Okay, and who is going to to do that examination? I am, says Mr. Levin. The court says, lucky guy. Are you ready to make an offer of proof? Mr. Levin says, yes, I am. I actually also have Dr. Carrie English, who's also my witness, who I'll need to be putting on first thing in the morning. Court says, okay. Well, we can always pick up. It seems to me that Ms. Simonton's testimony is briefer than the testimony of these other two witnesses, and the offer would be less time consuming. Mr. Levin says, perhaps, Your Honor, but I think that there is some, or should be allowed some expansion with respect to her testimony based on the cross-examination by Mr. Conn concerning the fact that Kathy Simonton was there at the same time that the last witness was. He elicited testimony regarding the feelings of. The court says, okay, we'll go through that. Ms. Abramson says, let's take our recess. Court says, before we get into that, it seems that it'll take a little while to deal with that offer of proof, the people's objections and things of that nature. I just don't want to keep the jury here while that goes on. And my feeling is we might as well excuse them until tomorrow morning and have them come in at 8:30 tomorrow, unless you can visualize finishing off this discussion of Miss Symington and starting her testimony this afternoon. Do you think you would be uh, we also have to deal with the issue of Dr. Dietz' situation? Ms. Abramson says, right. Let's let them go. Yes, we do. The court says, all right. Ms. Towery says, we also have Joan Vandermolen present, Your Honor, if the court is going to want an offer of proof with respect to her. The court says, perhaps we can combine that. Ms. Towery says, because we have a number of witnesses tomorrow. Court says, who else? We have, says Towery, Carrie English, as Mr. Levin indicated. We have Robbie Klaus, and I think we have Emmanuel Zlotolov. Who is that person? A neighbor of the pop, pop, pop. All right, says the court. He's the last pop, 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 so he heard the pops, says Miss Towery. All right. Is it stipulated that the jury may be released without further without further admonition, stipulated that they're deemed properly admonished and that they return tomorrow at 8:30? So stipulated, Your Honor. All right, let's have the jury excused until 8:30, and then we'll take a short recess and then resume. So we're just going to go right back into it. The lawyers are here, with the exception of Mr. Gessler. You want to proceed without Mr. Gessler, or do you want to wait? Ms. Towery says, I'd rather wait. Ms. Nahara says, actually, I believe there's one thing right now that I would like to deal with before 4. It's basically Mr. Levin and myself concerning the orders for this Saturday and Sunday. The court says, well, I've gotten from each of you an order. And my first question is, have each of you seen what the other one has proposed? And my second question is whether or not you've communicated with the sheriff's department to work out any problems. Mr. Levin says, "You want me to go first?" Ms. Nahara says, "You can go first, Barry." The court says the question can be answered yes or no. Mr. Levin says, "I just received." The court says, "You can't answer that, yes or no?" No. The court says, "Just like every other witness in the trial, and you'll do exactly the same thing." Mr. Levin says, "I'm afraid you'll assume I read it." "I just received the prosecutor's response proposed order, and yes, I did speak with the sheriff this morning." The court says, "Okay, and has the prosecutor spoken with the sheriff?" "Yes, we have, Your Honor," says Ms. Nahara. The court says, "Have your lawyers spoken between themselves about any issues the sheriff is concerned with?" "We spoke briefly this morning, Mr. Levin and myself," says Ms. Nahara. "Your Honor, if I can just recap, may what the problem is?" The court says, "First of all, let me ask my question. Did you talk to the sheriff about their concerns?" "Yes," and yes from both sides. The court says, "Okay, and have you resolved those issues?" "No and no" from both sides. Ms. Amerson says in unison. The court says, "Now we'll see if we can break this down. What is the problem?" Ms. Nahara says, "The problem, Your Honor, I've spoken to Deputy, it's either Cook or Koch or something, Koch." Says Ms. Abramson, "There are two orders on the table. The first order I spoke to them about, there doesn't appear to be a problem at this point with, that is, the people's order simply for the interview and the videotaping. That's not the problem from what he tells me. What he tells me, and I think what he also told me, what he also told Mr. Levin, is that his problem is with the defense order concerning the clothing and the situation and how he'll be restrained. I told him that the people had no position, and what the defense wanted to do was that they told the court, and we had no objection to that. And he said it was a problem with their upper management, and that he wanted to come down and talk to the court about the problem they were having with the defense order. So, as to the people's order for the interview and the videotaping, that seems to be met with his approval thus far." The court says, "Okay, Mr. Levin." Mr. Levin says, "That actually I spoke with Lieutenant Dwyer, who's the legal lieutenant who supervises those individuals that Ms. Nahara spoke with. He said that he would oppose the order that I proposed, which is that Erik Menendez not be cuffed, that Erik Menendez be allowed to wear civilian clothes. He did not speak to the issue about the availability of Erik Menendez to communicate if he had any reason to an attorney." This must be the for when he goes to the interview with Dr. Dwyer or Dietz. I'm sorry, right? It's the only thing I can think of where they would have an order with Erik not being cuffed, probably. Anyways, he did not indicate that he felt that none of this would be a problem if it was anyone else but Erik Menendez, and the only reason that these concerns even exist is because Erik Menendez is a high profile. He is handled as a high profile inmate, but it is not high security because of discipline or security or that he's a flight risk. It's merely Mr. Gessler now entered the courtroom. The court says, "Mr. Gessler, the post-trial motions have been scheduled for March." Mr. Gessler says, "That's fine, Your Honor. Any time before March 30th is great." Ms. Tower says, "I just informed him." The court says, "Just wanted to let you know there are certain matters you missed." "I appreciate that, Your Honor. I'm glad I wasn't here," says Mr. Gessler. Court says, "All right, go ahead. I'm sorry." Mr. Levin continues, "In any event, Lieutenant Dwyer did indicate that they would propose the order that I had submitted and did not want to be heard sometime in court." "Bring them in," says Miss Abramson. "They suggested to me tomorrow," says Mr. Conn. The court says, "All right. Is that when they wanted to come in?" The bailiff says, "Yes, that's what they told me, that they just want to have some information to go by. They have not received anything yet." The court says, "Okay, will they be willing to come in and talk?" Bailiff says, "I can call and verify." The court says, "If they're available and that's what they want to do, then we can just schedule some time when they show up tomorrow." Ms. Nahara says, "In the meantime, Your Honor, can we get our order signed and faxed over to them?" Ms. Abramson says, wasn't she just talking? No, that was Ms. Nahara. Ms. Abramson says, I don't want a partial order, Your Honor, because that gives the people what they need without giving us what we need. So I would ask the court not to sign anything until we've worked it all out. The court says, well, it can always be modified or vacated. The issue is whether or not they need something now to get going. That's the problem, says Ms. Nahara. The court says, certainly there's nothing in the people's order that is objectionable, other than you had some other objections of Dr. Dietz himself. Ms. Abramson says, just the way it's phrased as an interview that's going to go from 8:30 in the morning until 5:30 in the afternoon without designating any kind of breaks or access for the defendant. The court says, let me wait then and see if the sheriff really needs this before tomorrow. Okay, says Ms. Abramson. The other matter, if the court's prepared to hear it. The bailiff says, Your Honor, what time would the sheriff's department, whatever's good for them, will work it in? The bailiff says, Sheriff Koch, if he can get a fax or get a fax of both of the orders so he understands so they can do the research and address each issue. The court says, okay, and then when will they be here? The bailiff says, tomorrow morning, 9. The court says, okay, let's fax them copies of both. Both sides can do that. Do you have do each do you each have an extra copy that you can give to the bailiff so he can fix it? Mr. Levin says, can I have one? I gave you 3. The court says, just give him 1. Court says, okay, then we'll deal with it tomorrow morning. Okay, all right. So what else on this issue now, or do you want to just wait until tomorrow? Ms. Abramson says, I'm mindful of the court's previous expressions on the issue of discovery vis-a-vis Dr. Dietz and what he might be prepared to say, and recognize that we were operating under the assumption, well, he's just another witness who hasn't completed his evaluation, therefore, there's no discovery. Then, Mr. Conn is on television yesterday and all over the wire services telling the world my client heard it and the co-defendant heard it, even in the jail, that Dr. Dietz is going to testify that the molestation allegations are false, indicating that he's already reached some sort of conclusion. Now, we have been trying to reach Dr. Dietz for the past week to inquire as to what materials he has so that we could send him additional materials. He has sent back a message that he refuses to speak to the defense until after the interviews. Now, it is true, Your Honor, that it's always nice when you're cross-examining an expert to be able to show bias, and I have many examples of that already vis-a-vis Dr. Dietz. But there also gets to be a point when what we're doing here is an ambush. I'm sure it's no surprise to the court that I would prefer my client not be interviewed by Dr. Dietz. He regales in his reputation as witness for the prosecution. He has expressed publicly bias. He has expressed publicly bias against the defense. He has expressed it privately to me. So that isn't my choice. I'm also mindful that the court has ordered it and that there will be a sanction if my client refuses on my instruction to talk to this individual, but I am concerned now about whether it is appropriate to order an interview by a witness who's already made up his mind, who has wonderful credentials, but also a reputation for being biased for whatever side he is paying his, or whatever side is paying his $3.50 to $4.50 an hour. And I just don't think it's fair to allow this man who's made up his mind to use an interview with my client as an excuse when we know he's already made up his mind without some inquiry in advance or some information from the prosecution that we would have allowed Mr. Conn to make the kind of public pronouncements that were attributed to him yesterday. The court says, well, let's hear Mr. Conn's response as to what you said yesterday and the basis for it. Mr. Conn says, actually, I wasn't even interviewed by television yesterday, so I don't know. I don't know what counsel's referring to. I would like to see what that statement is myself. The court says, were you interviewed by anybody? I spoke to one reporter there was an audio recording that was made, but I don't even remember saying anything about Dr. Dietz yesterday at all. So I really don't know what counsel's referring to. We have a printout coming, says Ms. Abramson. The court says, all right, let's wait until we see what it is that was on the wire service, whatever, and then we'll deal with it. Let's go back then to the offer of proof as to the next witness here, Joan Vandermolen. I believe it's Kathy Symington, says Mr. Levin. The court says Kathy Symington. Mr. Levin says it actually will be Dr. Carrie English. The court says Dr. Carrie English, we don't need an offer of proof. So Kathy Symington. Yes, Your Honor. Her testimony will be related to her staying in the Menendez home in 1976. We did hear testimony mostly of cross-examination by Diane Vandermolen, who was also at the home, the Menendez home, at that period of time. Her experience, she was in a position to interact with Lyle and Erik and Jose and Kitty Menendez. Her experience during her stay was quite different than that of Diane Vandermolen. She would testify, if permitted, that she, along with Lyle and Erik and Jose Menendez, went to the swimming pool, that Jose Menendez trained and drilled both Erik and Lyle in swimming in much the same fashion that Diane Vandermolen testified to, that she felt that it was very strange the way that this training took place. She would testify to observations of Erik Menendez and how he reacted, in her opinion, that he was terrorized, that he was scared, frightened, and would cry, and how Jose Menendez reacted when Erik Menendez cried. This drilling would last 2 hours in an area of the pool that would be separate and away from any of the people who were at the pool that were playing and there to presumably enjoy their time. Her responsibilities at the house were, in essence, watching both Lyle and Erik Menendez. She would testify that the house was very, very tense when Jose Menendez was there, much more intense than than when he was than when he was not there. That there was actually a ritual that would occur prior to Jose Menendez arriving at the house, where if somebody had happened during the day that if something, oh my God, let me slow down in my brain. Sorry. My brain reads faster than my mouth and it doesn't always compute. So she would testify that the house was very, very tense when Jose Menendez was there, much more intense when he was there when than when he was not there. That there was actually a ritual that would occur prior to Jose Menendez arriving at the house, where if something had happened during the day, that Kitty Menendez was going to have to report to Jose Menendez, wherein it was felt that Jose Menendez would react negatively to the information that the ritual was that Kathy Simonton, Lyle and Erik and Kitty would greet Jose in a very special and purposeful way with the intention of trying to somehow allay his anger, and that she would know and have a great sense of impending doom when this greeting would occur. She would testify that at one, there was an incident where she was caught by Kitty Menendez smoking outside the garage at the Menendez house, and how Kitty Menendez got enraged, told her she was ungrateful, grabbed her physically, clenched her teeth, and made the same type of emotion that was indicated by Diane that that it scared her. And she saw this same behavior directed towards both Lyle Menendez and Erik Menendez, and that Kitty Menendez's rages were frequent yet unpredictable in the way of being able to associate these rages to any particular type of event. For example, in one incident, she broke the stem of a very expensive Waterford crystal glass and anguished over telling Kitty Menendez about it, but finally did, and Kitty had literally no reaction at all. But to other things that were very small or very incidental, she would go off into a rage. If permitted, she would testify that she saw Kitty Menendez on various and frequent occasions just staring off into space for no apparent reason, where she was almost catatonic. She would testify that these rages, that when she thinks about these rages, that it still scares her, that they were extremely intense. She would testify that Kitty Menendez yelled at her severely for not doing the household chores to which she was assigned according to Kitty Menendez's liking. She would testify, if permitted, that there was one particular incident wherein Lyle Menendez indicated that he did not want to play in a sport for that particular day, and Kitty Menendez threatened to tell Jose, and in fact did tell Jose, and Lyle Menendez was severely dealt with by Jose. We would offer that to show that the idea and concept of sports in the Menendez house was very serious business. She would testify, if permitted, that a common and frequent form of punishment by Jose Menendez was the sending of Lyle and Erik Menendez to their rooms, and when they went to their rooms, they would remain there for approximately a half hour to several hours, and that Jose Menendez would frequently go up to the room, close the door, and remain there alone with Erik or Lyle Menendez. That there was a rule that no one even went near the hallway when Jose was in the room with Lyle or Erik, which also applied to Kitty. This rule was expressed to Kathy Simonton directly by Jose. And later, an incident occurred when Jose was in the room, the bedroom, alone with Erik or Lyle, I'm sorry, I'm not certain which son it at this time. She got up to use the bathroom in the presence of Kitty and started to walk just in the general direction of the hallway. And Kitty Menendez told her to sit down and that she couldn't even use the bathroom because of the situation where Jose Menendez was in the bedroom with one of his sons. She saw this occur between 10 and 15 and 20 times. She would testify that no one disobeyed Jose Menendez's orders, that if permitted, she would testify that her observations of Kitty Menendez were such that she was not affectionate towards Erik and Lyle. The only time she saw any type of affection was if either happened to perform well at sports. She never heard any pet names associated to either Erik or Lyle Menendez by Kitty. She never heard Kitty even talk to them in a caring or affectionate voice. She would testify, if permitted, that Jose would take Lyle and Erik Menendez on weekends for games and practices, athletic games and practices, and upon their return, there would be, oftentimes and frequent times, extreme anger and tension directed towards Lyle and Erik, wherein, from the discussion, she could discern that it was over what Jose deemed to be poor performance at a tournament, a practice, or a game of some sort. She heard Jose Menendez tell Erik and Lyle Menendez on several occasions that they have to be the best. That she associated this with his desire for them to perform at peak performance every game they played, every practice they went to, how serious it was to Jose Menendez. She heard Jose Menendez, I don't believe anyone's testified to this, calling both Lyle and Erik stupid and other names frequently. She would testify that if, on some of these occasions, Jose Menendez would go to the room of Lyle Menendez, and it was much more frequent that she saw Lyle Menendez in the room alone with Jose Menendez, and perhaps this is so because at the time Lyle Menendez is 8 years old. Erik Menendez is, I believe, 5 3/4 years old, and this was at a period of time of when there has been testimony that there has been molestation by Jose Menendez directed towards Lyle Menendez. But in any event, she, if observed on many occasions, she observed Lyle Menendez following the incident alone with Jose in the bedroom, where she would describe the look on Lyle Menendez's face to be sad, blank, and expressionless. She said there was a difference. She would testify, if permitted, that there was a distinct difference in the way that Erik and Lyle Menendez were treated by Jose and Kitty, and that Erik was left alone much more. He was much more quiet and to himself, and she would testify, if permitted, that on several occasions she saw injuries associated with the boys' activities, be it falling off a bicycle, hurting themselves in some fashion, and she would testify that, in her opinion, Kitty Menendez had no concern not only for their safety, but would never tend to any of their injuries. Instead, she would tell them to clean and tend to the wound themselves. She never saw Kitty Menendez ever console Erik or Lyle Menendez when injured. She would testify, if permitted, that even at restaurants when they would all go out to eat, that Erik and Lyle did not order their food, that on every occasion Jose Menendez would order the food for Erik and Lyle, and even for herself, Jose Menendez would tell her what to eat. She recalls, and they would testify, if permitted, Lyle Menendez being ridiculed, berated, and, as she would describe it, anguished after he wet his bed, and the manner in which Jose Menendez treated him scared her. And also the same with respect to treatment towards Erik Menendez, who at that time had a speech problem wherein from time to time he stuttered, and Kitty Menendez would make fun of him, never offered him any help, and Jose would either make fun of him also or get angry at him when he stuttered. She would testify, if permitted, that it was the common knowledge within the cousins, at least in her family, that the Menendez family was, quote, the perfect family. She would testify, if permitted, that she actually asked to leave early and did leave early from this 76 trip because she was miserable at the Menendez family over the way that not only she was treated, but by the way Erik and Lyle were treated. I believe, Your Honor, that's the proffer. That's the proffer, Your Honor. Thank you. The court says this was a joint offer. Mr. Gessler says it's a joint offer, Your Honor. I have a little bit of additional to offer on behalf of Lyle Menendez, joining in everything that was offered on behalf of Erik Menendez by Mr. Levin. And that is an offer of proof that at the point at the swimming pool when Kathy Simonton was there, she observed both boys in the pool and heard Jose yelling at them, "You have to be the best," and then saying, "It's in your genes, you can do better." The significance and relevance of that, I think, is the extreme importance not only of athletic performance by both sons to Jose Menendez, but that he was making that obvious connection, that of identification with them. It's in the genes. Basically, you reflect poorly on me if you don't do better. And I think that's over and beyond just simply the parent at the little league type urging on of their sons. Additionally, in the bedwetting incident in which Jose Menendez was yelling at Lyle and berating him for the bedwetting, she described it as being a very intense situation in which Jose Menendez was standing, bent over in Lyle Menendez's face, just inches away, reflecting almost exactly the description we received from Alan Anderson on another situation in which the father was berating Lyle Menendez for having the misfortune of having been hit by a ricocheted rock. She described that the description of the face of Lyle Menendez was that of being scared. I think these two things are additional, at least additional facts to the offer of proof made as to the relevance to Lyle Menendez and the treatment his father gave him, instilling fear and also fear for bad athletic importance. Certainly not something that is within the realm of normal discipline or normal parental control of children. It's one thing to control the children, to even pick out courses or do whatever, but it's certainly something else to punish someone for losing or not doing well enough at an athletic event. Mr. Levin says, and just one other thing, Your Honor, and perhaps even the most relevant point, this witness too was Zolarized. The court says she was ambushed as well. Ms. Abramson says, I would object, Your Honor, to the people permitting to ask these witnesses, did you refuse to talk to the prosecution when they ask to talk to them when they're out in the hallway, are here awaiting testifying, have made no effort to contact them in the past, or if they made any effort, as with Alan Anderson, they did talk to them in the past. I think it's a trick. It's a game. They are being set up. They're being asked to talk to these witnesses when they don't have the time or presence of mind to do it, and it's just being used as a ruse to try to make them seem biased. It's not good faith. In other words, it's not good faith. The court says, well, the witnesses are able to, with the assistance of counsel, respond to the nature of the inquiry. The circumstances to why they declined to speak with Detective Zoller goes to the weight of not its admissibility. But they're not refusing, Your Honor. That's the whole point. It's not a refusal. It is I can't right now. Like, why are you asking me now at this late day? This is trial 2. Where have you been? Anyways, he goes on to say, clearly, if counsel for the defense walked up to the prosecution witness in the hallway before the witness was going to testify and asked to speak with them, and the witness said, wait until I get off the witness stand, you'd try to bring that out, and that's basically all that's occurring here. And if the witness has a reason why he didn't want to talk or she didn't want to talk, it comes out. I agree with you. It doesn't really amount to a great deal, but they're allowed to bring that out for the jury to weigh as far as bias. All right, did the people wish to respond to these particular offers? Court says, or Mr. Conn says, yes, Your Honor. I think that at a certain point, the offer of proof by the defendants should become transparent, and we should realize that this is just a transparent effort to put the victims in this case on trial. And it becomes more and more transparent as what we begin to listen to is nothing new but the same old claims over and over again that they want to bombard the jury with. At this point, none of this can serve any legitimate purpose. The defendant, Erik Menendez, already testified in regard to many of the things. Now we have the expert who has testified in regard to the things. We heard Alan Anderson testify to these things. We heard Diane testify to these things. And at a certain point, I think we should just say, enough is enough. We've heard this so many times. No legitimate purpose can be served by listening to it all over and one more time from yet another witness. That I think if we had just asked Mr. Levin, do you have anything new that's not cumulative at this point, Mr. Levin wouldn't have said anything. We started out with swimming training once again. This was that it was strange. We have a witness who is now going to call it strange. What does it accomplish by calling the swimming training strange? Well, violent for one, like aggressive for another. Like strange is not exactly the right word. I think unconventional and why it's unconventional needs to be looked at. That's important too. As far as Erik Menendez being terrorized or crying, or Jose's reaction to that crying, is something that was fully explored by the last witness. We have a proposal that the witness would say the house was tense when Jose was there. We've already heard this, that there would be a brutal, I'm sorry, that there would be a ritual where they would go up and greet Jose out of concern for how he might respond to his day. These are things that we haven't heard yet, so it should come in. It's not cumulative. It's not over and over. He gave many new examples that we haven't heard yet. So that argument doesn't fly. He says that has no bearing whatsoever on anything in this trial. That this witness was caught smoking by Kitty Menendez has no bearing upon anything. It's an introduction, I suppose, just to the fact that this was another opportunity for Kitty Menendez to clench her fists and grit her teeth. And once again, we've heard that from two witnesses now, not counting the expert and not counting Erik Menendez, that sometimes Kitty Menendez punished the witness and sometimes she didn't, has absolutely no bearing upon anything. It doesn't prove that Kitty Menendez was predictable. It just means that this particular witness didn't see a pattern. Maybe there was a pattern, maybe there wasn't a pattern. It doesn't mean that Kitty was unpredictable. It just means that the particular witness didn't see a pattern. What does that even mean? And the mere fact that a person doesn't display a recognizable pattern in her punishments doesn't mean that she is an unpredictable and therefore more dangerous person. So the whether a rational scheme could be devised from when this witness was punished and when the witness was not punished does not prove what they are seeking to prove, which is that somehow, as a result of this, Kitty Menendez was unpredictable and dangerous. It just doesn't follow. That Kitty would stare off into space proves nothing. Many people stare off into space. The rages were so intense, it still scares her. It's her own personal, subjective evaluation of what she perceived in Kitty Menendez. The underlying fact is something we've already heard now from Alan Anderson, from Diane Vandermolen, from the defendant, and from Dr. Wilson, that Kitty would report to misconduct by Lyle to Jose Menendez, offered to prove that. Therefore, sports was a serious business. We already know from numerous witnesses that sports was a serious business for this family. They took tennis seriously. What does that have to do with any of the issues before the jury? The punishment of being sent to the room, the rule that no one could walk down the hallway, has been sufficiently established by all of the witnesses in this case called by the defense. And one more isolated incident in which this witness has told you can't walk down the hallway right now doesn't prove anything. This is an area which, as we alleged in our original motion under 350 and 352, even a single reference to it, in our view, should not have been allowed because it has no tendency in reason to prove that just because the father would sometimes spend some time with his son alone in his room, that therefore the defendant was molested. The opportunity to molest does not prove the fact of molestation. You've got to be kidding me, right? I mean, right? Just because Jose wouldn't spend hours in the room with his sons and no one could go down the hall during those times, it doesn't mean the same thing. Even though the same rule applied for Erik, no. That's a bad faith argument. There is no doubt that throughout their lives with their father, there was plenty of opportunities for molestation, whether or not the witness recalls individual occasions in which that opportunity was present. There are undeniably countless instances in which Jose Menendez would have had an opportunity to be alone with his sons. So it doesn't prove anything to present evidence that a witness was not permitted to go down the hallway. But for whatever value it did have, and the court allowed it, we have now heard it. We've heard it from Alan Anderson. We've heard it from Dr. Wilson. We've heard it from Erik Menendez. And we've heard it from Diane Vandermolen. And at what point is enough enough that Kitty Menendez was not affectionate unless it came to sports? We've already heard abundant testimony concerning the lack of affection by Kitty Menendez. And we heard that from Erik Menendez himself when he said the only thing favorable he calls about her was her smile. So, why are we once again presenting more evidence of this? Pet names is something that I think has been previously excluded by the court. How much affection was in her voice is something that is entirely subjective and irrelevant. Anger at Lyle Menendez by Jose following the sports training is a matter in which is purely speculative. If Jose would come back from sports training with one of the defendants and he were to appear to be in an upset state of mind, one can only speculate as to why he's upset. Maybe it's totally unrelated to the sports event. We have no way of knowing that. And now counsel wishes to present before this jury matters which are purely speculative and sheds no light on the issues before this jury. That Jose would call his son stupid was an area that counsel indicated, well, here's something that no one else has testified to. He said, sort of suggesting his own recognition that everything that previously was indicated to the court is something that is certainly cumulative at this point. I don't think that Jose Menendez calling his son stupid is sufficient under Evidence Code Section 352 to allow counsel to present a witness just for that fact alone. In light of the other material that has been presented concerning Jose Menendez, there's a ton of evidence concerning his allegations against Jose Menendez and his relationship with the defendants, sexual, physical, psychological, and everything else. I don't see how this new name calling of being stupid is something which rises to the level that we have to take another witness concerning this matter. The look on the defendant's face as sometimes being sad or expressionless is again a purely speculative opinion that this witness nor any other witness could possibly be able to tie into any specific cause. It's purely speculative and it sheds no light into the issue before the jury. That Kitty Menendez did not tend to the defendant's injuries is something that we have already heard about. That Jose would order food for everyone else, including himself, is the type of evidence that the court has already excluded as being too trivial to even present to this jury. That Lyle was ridiculed and berated following wetting his bed is a matter that I believe has been presented to the jury already. That the witness was scared by the way that Jose Menendez would treat Lyle is an entirely subjective opinion, irrelevant and inadmissible as to Lyle Menendez. He did not take the stand in the case, and there's no reason to allow in further evidence concerning the relationship between Jose Menendez and Lyle Menendez, absent such evidence. That Kitty Menendez would make fun of stuttering is just one more allegation to put the parents on trial, which has no bearing upon the defendant's fear that the parents were going to kill them on August the 20th of 1989. That the Menendez family was regarded as a perfect family is an allegation which proves nothing for the defense. And yet, it is something, however, non lacking in probative value that was already testified to by the last witness. And additionally, that the witness left the Menendez residence to go home early because of the mistreatment that she received is once again her own personal and subjective conclusions regarding where she wants to be and at what time, and has no bearing upon the defendant's state of mind on August the 20th of 1989. So I would ask at this point, in light of the testimony that has been presented, in light of the cumulative nature of the testimony, what the court has allowed through the testimony of Alan Anderson and Diane Vandermolen, that this witness be excluded. Mr. Levin says, just briefly, if I may, Your Honor, perhaps Mr. Conn may have a legitimate position had he not engaged in the attempted search and destroy mission of the credibility of Diane Vandermolen. What Mr. Conn did with respect to Diane Vandermolen was call into question every single aspect of her testimony, and because of that, because of the inferences that are now laid in front of this jury as a direct result of the cross examination, there is a necessity by the defense to corroborate Diane Vandermolen's accounts with respect to the swimming incident, the observations that occurred back in 1976. And I think that that has special consideration by the court should be given with respect to the last witness, not only the treatment on the stand, but the viciousness of Mr. Conn in his attack on her credibility with respect to all her testimony regarding this particular incident. And even at one point, he questioned Diane following no direct testimony by Ms. Abramson at all about even the presence of Kathy, her sister, in 76. Mr. Conn asked considerable questions with respect to Kathy Simonson's presence, and he left inferences in the minds of the jurors that there is another witness who could testify to the ongoings that occurred in the 76 incident. Also, Mr. Conn has suggested by both Alan Anderson and Diane Vandermolen that both witnesses voluntarily stayed at the Menendez home and voluntarily returned back at a later time to give the inference that the treatment that they received. Hold on. I don't know what the hell my dog was just barking at. And then she ran outside, but she's looking out the front window. Do your dogs do that? Like they bark out the front window, but then they run out to the back and bark some more? I don't know. Anyway, so where was I? Mr. Conn also suggested by both Alan Anderson and Diane Vandermolen that both witnesses voluntarily stayed at the Menendez home and voluntarily returned back at a later time to give the inference that the treatment that they received was not only tolerable, but was so good that they wanted more. And we believe we have a right to present rebuttal evidence to that we have a witness that actually had a different view of the way that she was treated during this particular time, who left early because she could not tolerate the conditions that existed in the Menendez home. Also, with respect to not only corroborate Erik Menendez's testimony, but give credence to the testimony that he gave and rebut the inferences by the prosecution when he continuously, over objection by the defense, went into the relationship that he had with his mother and his father, why there were no loving memories. Mr. Menendez's so-called superficial relationship with his alcoholic, depressed, middle-aged housewife mother. These are witnesses, and the only witnesses who spent considerable time and were allowed into the Menendez home that can testify to what they observed while they were there. It's not a parade of witnesses that lived in the Menendez home. These witnesses are the few witnesses who actually spent time in their home for a considerable length of time. So, for that purpose, we believe that all the events that I have requested this court allow this witness to testify to are relevant. They're admissible, they're corroborative, and they rebut and refute the prosecutor's inferences that he left the jury on the cross examination on the last witness. So, the prosecutor's fault that they have to get this in because the prosecutor went heavy on Diane, making it seem like she's not credible. So they have to get this in order to back up Diane and Erik. Mr. Gessler says, just briefly again, Your Honor, the court says yes. I join in the remarks of co-counsel, and also I think the district attorney misapprehends the relevance of the pool incident I spoke of and the young men being sent to their room for not being doing well enough in athletic events. Again, a transcript is great in showing what words are said by a witness and what words are spoken by a question, but they do not in any way reflect the tone of voice as to how questions are asked. And when Erik Menendez testified that he felt that one of the, if not the reason that he was disinherited by his father was because of failure to report on the tennis lessons, practices, and so forth, communicating enough with him, and that he fell to number 70 in tennis. The tone of voice in the cross examination on that aspect by Mr. Conn was one of sarcasm and mocking that does not come across in a simple reading of the transcript. But it was certainly an attack of the credibility of Erik Menendez when he testified to that. And now we have a witness who can show that, indeed, in saying that it's in the genes and his way of egging the boys on and how important athletic endeavors was to Jose Menendez, that it corroborates the fact that he is the type of man who would kick somebody out of the will for falling down in their tennis ratings. That it is that important to them. The court says, okay, the court, first of all, premises its remarks by reference to the time frame here. This is 1976. Ms. Symington's testimony related to, Ms. Vandermolen's testimony related to a much broader time frame than Ms. Symington's proposed testimony, and all of these events that are proposed by Mr. Levin really relate to a period in 76, which is, by anyone's analysis, more remote from the events of 89 than some of the other testimony of Ms. Vandermolen. However, her testimony was subject to impeachment and attack, and but for the nature of the examination, the court would agree that the totality of her testimony would be cumulative or otherwise irrelevant. However, I believe that there is some small portion of her proposed testimony that would be admissible to corroborate the testimony of Ms. Vandermolen and the defendant Erik Menendez. Again, the testimony is offered not because it itself has any significance in describing events that in isolation have no significance, but only as a basis for the expert opinions rendered by Dr. Wilson, but for that would have no relevance in this trial and would be completely excludable. And those remarks relate not only to Ms. Symington, but to Mr. Anderson and Ms. Vandermolen. Getting to the specifics, I don't recall her testimony from the first trial as to how she described the so-called swimming endeavor, but if it tends to corroborate the description of Ms. Vandermolen, then it would be admissible on that basis, that it's corroborative of her testimony, since a great focus of the cross-examination by the prosecution was to attack Ms. Vandermolen's description of that particular practice that involved Mr. Menendez and Erik Menendez. So, if she has testimony to offer that would corroborate the testimony of Ms. Vandermolen in that regard, I think it would be relevant and non-cumulative. As to the other offers here, going through them, the behavior in watching for Mr. Menendez to arrive and the ritual that was described by Mr. Levin, I don't find that there's any probative value in that. It's remote in time, and any potential probative value is substantially outweighed by its potential for confusion of issues, and therefore it would be excluded. The smoking incident, as described by the witness, has no relevance, and I agree with the prosecution's analysis. It should be excluded. If she describes unprovoked rages by Mrs. Menendez during the time frame of 76 to corroborate the testimony of Ms. Vandermolen, it would be relevant and admissible for the purpose of corroborating her testimony. Mr. Conn says, Your Honor, if I could just object to one thing, if the court would allow me. The court says yes. I believe what the witness testified to was that the rages started in 78, that she saw none in 76. The court says, I said if it corroborates. I don't have recollection that she did describe anything in 76. Ms. Amerson says, she said more later. Mr. Conn says, no, but the last witness testified that there was none in 76. They saw them in 78, so it can't corroborate the last witness. Ms. Abramson says, good, then it's independent evidence of additional rages going back even earlier, either way. The court says, well, as I view it, this witness would only be admissible to corroborate the testimony of the previous witness. So if there is, and if you can review your notes or find it in the transcript before she testifies as to the 1976 then it would be admissible, but only to corroborate. I agree with the prosecution. This is otherwise cumulative evidence or otherwise irrelevant. As to the staring in space and the almost catatonic behavior of Mrs. Menendez, it's irrelevant, doesn't really connect anything or prove anything, and would be inadmissible. Yelling at the witness for her poor housekeeping, again, wouldn't have any relevance or probative value. The preference expressed by Lyle Menendez that he didn't want to participate in certain sporting events, and the report by Mr. Menendez and Mrs. Menendez and the discipline. Hold on, the dog's trying to lay on my hand as I'm trying to scroll down the page. The preference expressed by Lyle that he didn't want to participate in a certain sporting event, and the report by Mrs. Menendez to Mr. Menendez and the discipline, again, this is remote in time and has no relevance, and that would be excludable under 352 of the Evidence Code analysis. The sending to the rooms and behavior of people as to whether they can or can't be in certain portion of the house, that is cumulative. We've had other witnesses describe the same events. That they can't go down the hallway? Sending to the rooms. Mr. Levin says, Your Honor, if I may, the reason that I feel that the court should give some special consideration to this particular body of evidence is because of the cross-examination by Mr. Conn of Erik Menendez, where he especially asked Erik to name the witnesses who are aware to the rule of the and he named these people. And so, if they are not allowed now to testify, he did name Kathy. He said Kathy, and he said, and then I cleared it up that it was Simonton, and he mentioned Diane. He mentioned, I think it was Andy Cano. Okay, says the court. If that's in the testimony, find it. And if it's true that that's what he said, then I'll permit it. It's a corroboration of Erik Menendez. All right, then going through here to no one disobeying Mr. Menendez's orders, that's a conclusion, and again, remote in time and irrelevant. Similarly, the affection shown by Mrs. Menendez only if they did well in sports, that's cumulative and again, remote in time. All these other materials that were mentioned by Mr. Levin likewise are either cumulative evidence or irrelevant and under analysis under Section 352 of the Evidence Code. The probative value of any of this is substantially outweighed by its potential for confusion of issues. And because it is remote, it lacks real probative value in this case. So, all of these other matters that have been identified by Mr. Levin likewise would be excluded. As far as her reason for leaving the Menendez home, we'll wait for the cross-examination to see how that gets brought in. Oh, he like sucks the breath out of me when he sits on me. So sorry. Ms. Abramson says, gee, you shouldn't have said that, Judge. What did he say? Oh, wait, see how the cross-examination goes. The court says, but what often occurs on cross-examination is introduction of evidence that was objected to being brought up in the direct examination. But I can't rule at this point. I don't see her personal opinions as relevant. So unless there was some specific further argument you wanted to articulate as to these different matters, both as to Mr. Levin's offer and also Mr. Gessler's offer, I don't really see that things are relevant. And whatever relevance they have, they've already been covered by other witnesses and are cumulative, and also potential for confusion of issues here by the repetition of them. So those are my rulings. We have a couple issues that need to be clarified by reference to the transcript, one of which I've ruled admissible regarding the swimming based upon the corroboration of Ms. Simonton or Ms. Vandermolen. What is the offer of proof as to the sister who's coming in? You mean Joan Vandermolen? Yes. All right, Your Honor. I'll tell you, says Ms. Abramson. Very brief. She testified very briefly the first time too, and it's basically, with one exception, the same. Let me just pull out my witness summary. I have a one-page summary. She recalls an incident between having to do with Erik Menendez, who was playing at the Fiesta Bowl in Phoenix, which is where this witness lives, either at the tournament in 87, which would have been between Christmas and New Year's in 87, or the tournament in 88, which is also between Christmas and New Year's. And I would submit, Your Honor, if necessary, we could put on a witness who would establish that it, in fact, was the 88 one if we have to go that far. We have an independent witness to that effect. That on a day when Erik Menendez lost a game, his father took him and was alone with him in his hotel room for a significant period of time, a couple of hours, and then came out and announced that Erik was not going to go to dinner, that he would rather stay in bed, that he has a lot to think about. And the court says, has this been described by the defendant in the testimony? Yes, yes, he talked about the Fiesta Bowl. Court says this related to a sexual assault? Yes, the Fiesta Bowl sexual assault, as I would think of it, as compared to the Louisville or Kalamazoo one, which comes the next year. Okay, she also testified that she and other members of the family were at the Beverly Hills house on either the Tuesday or Wednesday following the homicides, that it was herself and other identified members of the family who she'll name who started going through the family computer and hitting various keys and giving various instructions to try to bring up a will file. That as they were scanning through the computer, they came upon the word will. They tried to bring it up as a file. They could never get past the directory. And we suspect these are the culprits who unknowingly, the court says, okay, I understand. She says, you understand that? So that's really straightforward. She found a pornographic videotape in Kitty Menendez's closet in November of 1986 that's very brief. We'd like to bring that in. It corroborates Erik Menendez, who said he found a bunch more in his parents' bedroom area earlier on and had removed them. I'd like to bring out the fact that she spoke to Kitty Menendez frequently and for long periods of time, and she never told about Mr. Menendez's affair, even though Mrs. Menendez told her that she was seeing a therapist and she was on medication, that she was depressed. But not only did she never tell her about the affair, she specifically went out of her way to lie to Miss Vandermolen to tell her a story that proved the moral of which, or the punchline of which, was that Jose Menendez was absolutely faithful to her and he abhorred being at a gathering where men actually brought their mistresses. I'd like to bring that out to show just exactly how determinedly secretive and unfaithful she was, or untruthful she was. And that one incident we are talking now about, a very recent event close in time to the homicides. I would like to bring out this witness's knowledge of how important public perception and image was to Mrs. Menendez as a characteristic of their family, and that it was extremely important to Mrs. Menendez in the year 1988, 1989, and something that she would have talked about to corroborate my client, that public image, public perception, and the lack of scandal was extremely important to his mother. And I'm not sure what this means. Let me cross-reference the transcript for a second. Sometimes the summaries are not accurate. Okay, that's it. The court says, okay. As far as the incident in Phoenix, I don't have a specific recollection of the defendant testifying about this event. I recall one. I didn't know there were two similar events, but is there any dispute about the defendant describing a sexual assault in Phoenix after a tennis tournament? Mr. Conn says, well, I would have to check my notes about that and see what he said about that. Court says, all right, assuming that he did, and if it's in the testimony, it would be relevant to corroborate his testimony what this witness observed. Likewise, the testimony about going into the computer and what she did with the computer would be relevant to explain why it had certain materials on it. As far as the pornographic videotape, does she describe what that tape was, or Ms. Abramson says she took it and she looked at it, and it was a pornographic video. I never asked her for anything more detailed than that. I'd rather not, but perhaps she remembers the details, or perhaps she was so offended once she saw naked bodies that she turned it off. We never got into details. The court says this was something in whose room? Kitty, Mrs. Menendez's closet. This was in November? Right. She was going through more of Mrs. Menendez's possessions at that time, and there was one video that turned out to be pornographic. Now, I point out to the court that this witness previously testified that she found a sexually explicit novel and sexually explicit letter written by Mrs. Menendez in the nightstand next to Mrs. Menendez's bed, and I'm not seeking to introduce those. Huh. Okay. The court says, all right, the people want to be heard on the videotape. Yes, says Mr. Khan. The problem with making an allegation that this was pornography is like the Supreme Court justice said, I know it when I see it. Well, what is it that has her say this was pornographic? She said the same thing about the novel, and she said it's pornographic too, and she said it's the same thing you can pick up in grocery stores. We don't really find pornographic novels in grocery stores. It tells you a little bit about her standards and what she calls pornographic. There's no reason to believe it was pornographic. And even assuming it was, if by pornographic she means sexually explicit, and I think there's a distinction, but even if she says it was sexually explicit, I don't think that the defendant should be able to present this. A single sexually explicit tape possessed by a man and his wife in their bedroom should not be the subject of this proceeding. Again, it's just another way of putting the parents on trial. I don't think that this is relevant, and it doesn't corroborate the defendant's claims that he found a whole box. One has nothing to do with the other. A single sexually explicit tape does not provide him any corroboration of finding a whole box of tapes. And of course, it's our possession that even if he did find a whole box of tapes, even that in turn doesn't prove that he was sexually molested or that he feared that his father was going to kill him. And that's the problem with the type of evidence that's being offered by the defense. We keep getting one step further and further and further removed to the point where we're now trying the parents for having one single sexually explicit tape in their bedroom. And I just don't think it's relevant and it should be excluded under 352. Ms. Abramson says that's not the purpose. I mean, it's a little more subtle than that. Prosecution attacked, first of all, they put on Brian Anderson Sr. to talk about, and Mr. Wright to talk about the will and the fact that the defendants wanted to look inside the safe out of the presence of other people, and they brought out the defendant's statements, or Lyle's statements, that they were looking for personal, embarrassing, potentially embarrassing materials. The whole point here is not that the pornography had anything to do with the molestation. We have other pornography that may have had something to do with the molestation that we haven't put out the evidence yet, but we will. The point is the notion of extreme protection of their parents and their parents' reputations and their parents' secrets after the homicides that both defendants engaged in, that Erik Menendez has offered as part of the reason why he was not prepared to talk about bad things that his parents did after they were dead, after they were killed, which supports what he wears on, or what we hear, what we hear on the 1211 tape about his unwillingness to discuss negative things about them. The point here was that Erik testified he took out a box of porno videos not because they were linked to the molestation. He never said that. And if lies are what Mr. Conn likes to argue, Mr. Menendez was lying about the molestation. He could have easily said, my father had a box of videos of men doing it with boys that he showed me my whole childhood. He didn't do any of that. The point of the porno videos is not that they are proof that Mr. Menendez was a molester, but it is proof by Erik removing them that the children were trying to protect the image of their parents after the homicides, and that has a great deal to do with what's going on in the 1211 tape. The court says, all right, assuming that's true, his testimony is before the jury. I don't find that finding a videotape by Mrs. Menendez's sister proves anything. I suppose the argument is the defendant didn't do a very good job and would be criticized for it by not cleaning out the closet effectively. I don't see this as relevant here. The fact that something was found later on, I agree that there is this factual issue that would just cause confusion as to what this witness would describe as pornography versus what somebody else would or wouldn't. Ms. Abrahamson says she would say sexually explicit. It really doesn't matter. Right, says the court. Ms. Abrahamson says, right now we're splitting hairs over pornography. The court says, no, we're not doing that. Ms. Emerson says, but when Erik Menendez testified it was pornographic videos, the didn't even ask him what was on them. The court says, right, I don't see how whatever the witness found 3 months later is corroborative of the defendant's testimony that he did in August in removing things from the closet. As to why, whether Mrs. Menendez spoke to this sister about Mr. Menendez being faithful or not being faithful, I don't see how that has any relevance in this case, quite frankly. Ms. Abramson says, well, I think it has to do with maintaining that false point, that aspect, lying, in order to make the family appear perfect and to maintain that false front, and all of which, connects to the children wanting to protect the image, the children keeping secrets, the children being taught to lie. All that stuff I'd like to get into. The court says, okay, I just don't see it relates to even those offers of relevance that you're just now articulating. That's a separate issue and speaks more for the relationship Mrs. Menendez had with her sister than anything else as to what she would or wouldn't say to her sister. Mrs. Abramson says, except she didn't tell anybody, Judge. The court says, well, I think Mr. Anderson testified in the first trial that he had been told by his sister about such matters. Said Jose had a fidelity issue. The court says, okay, well, that's what was said. Ms. Amerson says, but he didn't know she was seeing a therapist or taking drugs or was depressed. The court says, okay, still, what one person chooses to say to one family member and not to another, I just don't think this trial should be involved with such matters. It's totally irrelevant to the issues in this case. So that basically is your offer? Yes, says Miss Abramson. The court says, okay, so the first two items would be admissible and the other two are not. Okay, tomorrow then, 9, we have the sheriff here. Perhaps they might get here a little early, so I'd ask everyone to be here at 8:30 so we can resolve that if everyone is here, and also any other loose ends. Well, he asked the jury to be here at 8:30, so why wouldn't you ask the attorneys to also be there at that time? He says, Dr. English will be the first witness, is that right? Mr. Levin says, yes, Your Honor, and Ms. Towery did find that reference in the transcript if the court wants that now. As to, says the court, Mr. Levin says the testimony of Erik Menendez, wherein he was asked and testified, that names the witnesses. Okay, says the court. Ms. Towery says that's in volume blah, blah, blah. That's where he names Kathy Simonson specifically. Court says, okay, we'll be in recess until tomorrow. And they complete January 17th, 1996. So we will continue on next week, Sunday, with the continuation of our witnesses. So we've got Dr. Carrie English first, and then perhaps Kathy Simonton, Joan Vandermolen, and some others. So that's what you guys can expect. Let me know what you're thinking in the comments below, and I will see you guys in the next one. Thank you so much for watching. Take care. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.